My lord, I have some old cases. 2013 matter, 14 matter, long back matter has not been listed. So next week,
In which column? Hearing column or admission?
actually, one is already directed to list for hearing, long back, not listed. After hearing column.
But before vacation, we are not in a position to accommodate you.
Let the matter come. If not possible, after vacation it will be taken.
No, it will come after vacation only. Immediately after reopening.
May I have,
You can suggest that from him.
may I have your lordship?
Yes.
Lordship, with the consent of the other side, I beg to mention item number 10 and 15 of the daily list, lordship. Lordship, the matters may be adjourned for the day, lordship.
Your Lordship, I'm for item number 10, respondent number 3 and 4.
Yes, your good name?
A Singh, lordship.
Mr. A. Singh, learned counsel for the appellant.
In item number 10, I am for the appellant, lordship, and in item number 15, I am for respondent number 1, lordship.
Where is your name in the Okalatnama? Oh, no, sorry, in the cause list.
I am appearing on behalf of R.K. Bhuiya, lordship.
Why don't you telling his name then? Appearing on behalf of Mr. R.K. Bhuiya, learned counsel for the appellant, with concern from the other side, press for listing the matter. Where?
Lordship, item number 10 may be fixed on Tuesday, that is 17th, lordship.
Sorry,
Your Lordship,
only after vacation.
Your Lordship, we had already filed an IA for early hearing. And today was the date fixed for that.
Which matter?
Your Lordship, for item number 10.
So if we adjourn the matter, then it will be listed only after the vacation.
Your Lordship, any date in the next week? if
No, sorry.
Vacation.
possible. A date, Your Lordship.
Public.
Item number 15. Mr. So-and-so, learned counsel appearing on behalf of Mr. R.K. Bhuiya, learned counsel for the respondent, with consent from the other side. You inform the other side in 15, item
Yes,
number
lordship,
15.
we have taken the consent, lordship.
From whom you have obtained a consent?
From N.H. Mazhar Bhuiya, lordship.
Recess will list the matter after vacation.
Public.
May I please, your lordship? Item 14, your lordship. Appellant has already expired, your lordship.
14.
Appellant expired, so substitution petition has to be filed, your lordship.
Mr. N.N. Upadhyay, learned counsel for the appellant, submits that the appellant of this case suffered demise long back, and his legal heirs, the name of his legal heirs are to be substituted, and accordingly prays for 1 week time or 2 weeks. 1 week or 2 week?
2 weeks.
2 weeks time. Here is accordingly allowed. Prays shall list the matter after 2 weeks.
Public.
My lord, I beg to mention few MFAs. It's our old matter. All of them has not been listed in 3 to 5 years. All of them are 2013 appeals.
Only after vacation.
My lord, any date may be fixed up.
No. Before vacation, no.
After vacation,
After
my lord,
vacation,
any date.
take a date from him.
Much obliged.
May I please also, my lord, I beg to mention for listing new case, my lord, RSA, my lord. My lord, it was filed on, my lord, 11/10/23. It was defective and it is rectified. The case is transferred to the establishment for numbering, my lord. But till yet not listing, my lord. Very urgent, my lord. The execution process is going on, my lord. My lord, maybe listed this week or next week, my lord.
This week not possible.
My lord,
Next week we may try.
My lord. Next week, my lord.
COVID.
On 27th.
27th of last, my lord.
May I please, your lordship? I am the respondent of item number 25. With the consent of the other side, this matter may kindly be passed over for a day only. Date may kindly be taken.
Your good name, please.
M. Bhattacharya.
Ms. M. Bhattacharya, learned counsel for the respondent, with consent from the other side, press for listing the matter. When?
24th September.
24.
It is very urgent, your lordship.
Possible. So it will come in a usual course.
No, your lordship, it is very urgent. That's
No,
why.
sorry, it is 2023 matter.
For the appellant, can it be on 24th? For the appellant, your lordship.
24th,
Yes, appellant.
24th. No, now we are considering 25 only. So before vacation, madam, not possible.
For me, it's okay.
You are in 24.
Yes, lordship. 24 or
25.
before vacation, any date, your lordship.
25.
In 25, you are for the petitioner.
No, lordship, I'm for the, yes, appellant, lordship.
What is your name?
JC for appearing on behalf of M. Biswas, your lordship.
Okay, as agreed by learned advocates of both sides, rescission is the matter after vacation. After vacation.
Yes, next week. May I please, your lordship. So I'm praying for listing of a new IA on Monday, your lordship.
Possible.
Not Monday, on Wednesday, I think. Your lordship, because in next date fixed in the lower court is on Wednesday, your lordship, that's why I'm praying. On the cases a bit higher.
Okay, I will try, but your matter may not reach on that day.
May I please, your lordship? Lordship, in item 24, I prayed for adjournment, lordship, with the consent of the other party.
You are for?
I am for respondent, my lord.
What is your name?
A. Ali, on behalf of MJ Borua.
Mr. A. Ali, learned counsel, appearing on behalf of Mr. M.J. Borua, learned counsel for the respondent. With consent from the other side, press for listing the matter. When?
My lord, after 2-3 weeks,
After vacation.
kindly fix a date, my lord.
Okay.
So vacation on 5th November.
Obliged.
May I please, your lordship? Lordship, I beg to mention one RSA for listing, lordship, in motion column.
When?
And it's on Wednesday, lordship, next week.
Wednesday.
20.
Lordship, I also beg to mention supply item number 26. With the consent of the other party, kindly the matter may be adjourned, lordship.
You are for?
P. Hajarika on behalf of S. Roy.
Ms. P. Hazarika, learned counsel, appearing on behalf of Ms. S. Roy, learned counsel for the appellant, with consent from the other side, press for listing the matter. When?
After 2 weeks, lordship.
After 2 weeks. They are allowed.
Please.
May I please, your lordship? Lordship, I beg to mention a RSA matter for listing in the admission column.
When?
My lord, if possible, tomorrow,
No.
next week.
30 September.
Can it be on next week? There is an urgency actually.
23rd.
23rd. Obliged, ma'am.
Items from daily list, promotion bail application, item number 1.
May please, your lord. My lord,
Yeah, lordship, the scan copy will be required, lordship. Scan copy of the LCR, lordship, will be required, lordship. That is not in the record, lordship.
lordship, I call for the scan copy, my lord, of the LCR.
No, on the other day, we have adjourned the matter to show the change of circumstance in favor of the accused.
My lord, then on that count, I may address your lordships, my lord.
Ah.
In fact, my lord, what I have, my lord, understand, the ratio laid down by the honorable.
No,
Supreme-
sorry, you were not supposed to reopen those matters.
No, I'm not trying to reopen, my lord.
No,
I'm trying to
you,
make my-
you saw, is there any change of circumstance in your favor or not?
What I'm trying to say, my lord,
Ah.
change of circumstances always is not necessary, my lord.
Hmm.
In the present facts, what I'm trying to say, the Honorable Supreme Court has said that the successive application will not be maintainable. When the High Court makes a finding, records a finding that the accused is prima facie, my lord, involved in the commission of the offense. My lord, I'm trying to catch up my breath, my lord. Coming. Now, what has happened, my lord? from the two orders
Hmm.
passed by your lordships, my lord, earlier
Hmm.
rejecting the bail application,
Hmm.
your lordship has expressly not provided that the accused is, my lord, involved in the commission of the offense.
Hmm.
What I find from the operative
No,
part
no,
of the order,
whether this prima facie case is not reflected in the in the order.
my lord, in fact, the argument of the, my lord, learned additional PP was
Hmm.
that the earlier bail application having been rejected,
Hmm.
the subsequent bail application is not maintainable.
Hmm.
And relying on, my lord, the case of Papu Yadav,
Hmm.
your lordship had, my lord, rejected the case.
Hmm.
And if your lordship comes to the operative part,
Not only that ground, but some other grounds
yes,
are also assigned.
other ground is the submission of the petitioner is, so far as, my lord, the recovery is concerned, there is no recovery from,
Hmm.
my lord, his possession. That is
Mm.
admitted fact. Your lordship has also recorded.
Hmm.
Secondly, my lord, there is a statement of the co-accused under section 67.
Mm.
Now, your lordship has also recorded that this is not, my lord, admissible in terms of, my lord, the Supreme Court judgment.
Hmm.
Now, only evidence which remains, my lord, is the call record. Call, my lord, record details.
Mm.
Now, this CRD, my lord, in fact, has to be supported by a certificate under section 65B of the Evidence Act.
Hmm.
Your lordship is aware, this is a mandatory requirement.
Mm.
Now, in the order, my lord, there is no observation that the call record details, my lord, is supported by the certificate.
So,
So in that
Mr.
context,
Talukdar,
my lord,
while deciding the bail application, what is the requirement to be seen by
my
the
lord,
court?
absolutely, there is a requirement because unless your lordship finds that the, my lord,
So
call
only
record
the
details-
prima facie case?
there is not a prima facie case because if your lordship finds
Hmm.
that it is not supported by a certificate, that is
Hmm.
not admissible in law. It has
Hmm.
no value in the eye of law, my lord.
Hmm.
So this is one of my ground, my lord. In fact, your lordship, if your lordship peruses the records and your lordship finds that there is a certificate, I have no case. But
Hmm.
if your lordship finds that there is no certificate at all, which is a mandatory requirement,
Hmm.
then this call record details, my
No,
lord.
Mr. Talukdar, certificate can be produced at any point of time.
No, my lord, what I'm trying to
Hmm.
say, while my lord,
Even if at this stage the certificate is not furnished by the IO, he can produce at any point of time during trial.
my lord, my respectful submission is,
Hmm.
while recording, my lord, that there is a connection between the accused
Hmm.
persons, my lord.
So we are not supposed to express the view of the court,
Yes.
express the opinion of the court in respect of the entire merit of the case. We are only to see the prima facie case at this stage.
My lord will kindly see, my lord,
Hmm.
that my respectful submission is,
No, now you tell me what are the change of circumstances in your favor.
my lord, here, your lordship will see the, my lord, this was rejected,
Hmm.
my lord, 2 months back.
Hmm.
This application, my lord, it
Hmm.
was rejected in the month of June.
Hmm.
Now, by this time, 3 months have gone by, and
Hmm.
your lordship is aware that, my lord, my right under 21 is also has to be weighed by your lordship being a constitutional court, my lord.
Hmm.
Now, what the Supreme Court says, my lord, these stringent provisions, my lord,
Hmm.
like the NDPS cases, my lord,
Hmm.
it has two consequences, my lord. Firstly,
Hmm.
it curtails the freedom of the court as well as, my lord, it fetters the discretion of the honorable court, my lord, to grant debate.
Hmm.
So, my lord, the constitutional provisions, my lord, when it is challenged before the honorable Supreme Court,
Hmm.
these are upheld, my lord, by balancing, my lord, the two interests.
Hmm.
Firstly, the interest of the, my lord, personal liberty of the accused, and
Hmm.
secondly, my lord, the requirement of the society to prevail the law and order situation.
Hmm.
Now, here, my lord, my humble submission is, if your lordship proceeds on the ground
Hmm.
that, my lord, he may be innocent, my lord,
Hmm.
then under such circumstances, lordship may have the discretion, my lord, to pass a, my lord, bail order. And
Hmm.
secondly, having regard to, my lord, the length of detention,
Hmm.
charge has been framed, now I am behind the bar. So there are
No,
judgments also.
is there any proposition of law that always length of detention is to be considered in
Absolutely, my lord.
serious cases?
There are the judgments, my lord, because
Hmm.
there are, in fact, the constitutional bench judgments also.
Okay, we will hear you. We will hear you.
Yes, then in
At
that
this
case-
stage, let the scan copy
Yes,
of the
yes,
record come.
absolutely, my lord, correct.
This application under section 483 of the Bharatiya Nagarik Suraksha Samhita 2023 is preferred by accused Sri Abdullah Al Muhammad Chaudhary alias Abdullah Chaudhary alias Bablu, who is languishing in jail in connection with Karimganj PS case number 334 of 2023 under section 21C 25 29 NDPS Act since 5/5/2023. Where is the petition and the documents plus on record? let scan copy of the record as well as status report be called for from the learned trial court, fixing the matter on when?
Around 30.
13. Rest is the call for.
Deeply abreast. I'm deeply abreast.
Order number 2.
My please, your lordships. So this is an application under section 482 BNSS 2023 lordships. The petitioner lordships, the fact of the case is that lordships, the petitioner vehicle was intercepted by the police at Tinsukia lordships and recovered lordships 20 to 25 number of bulls lordships. Now present petitioner is the owner of the vehicle lordships. The FIR your lordship will find at page 8 lordships.
It is search case or not search it?
This under investigation, lordship. Under investigation, lordship, not charge sheeted.
Pardon?
Not charge sheeted, lordship.
Heard Mr. T. Sutia, learned counsel for the event, and also heard Mr.
Is on.
learned counsel for the respondents, that respondent. This application under section 483 of the BNSS is referred by accused. 482 of this BNSS is preferred by accused Nisar Ahmed, who has been languishing in Jailazut in connection with, who has been apprehending arrest in connection with Makum PS case number 68 of 2023 under section 120B, 333, 353, 307 IPC, that is section 11, 1D of the Prevention of Cruelty to Animal Act 1960, read with section 13(1), Assam Cattle Preservation Act. Having heard the submission of learned advocates of both the parties, it is provided that rest is shall call for the the learned additional PP shall produce the case before this court on when?
On 27.
May pay for interim lordships because his vehicle is lying under police station for last 1 year lordships.
Pardon?
May pay for interim lordships because his vehicle is
Sorry.
lying in the police station for last 1 year lordships.
307 and 333 are there. Let us see the come. If there is no material, definitely we will extend the period.
Item number 3.
Lordship, as on date, my lord, the petitioner is behind the bar for 3 years, 54 days. Now, my lord, I'll just take your lordship to page 48. Your lordship order was there rejecting the bail, wherein your lordship has specified that 309 provision will be invoked. The case may be split up against these accused persons, my lord, and trial should proceed, my lord. And that order your lordship would find on page 48, my lord. Thereafter, my lord, now almost 2 years, my lord. The trial has not proceeded, my lord, and they have recently filed an objection, my lord. And the objection is, my lord, filed on 22/8/2024, my lord. That also I'll show, my lord. Now, my lord, the operative portion is at page 49, my lord. Last para, my lord. In view of the above, as agreed by the Learned Counsel for both the sides, this application stands disposed of by directing the Learned Court below to take records of section 309, subsection 1.
Page number?
Page 49, my lord. Page 49. Well, 48, the order starts, my lord.
Yes.
That was passed on 11/11/2022, my lord.
Mm.
And thereafter, my lord, next page 49, my lord, last para, my lord.
Mm.
In view of the above and as agreed by the Learned Counsel for both sides, this application stands disposed of by directing the Learned Court below to take recourse of section 309, subsection 1 CRPC and to dispose of this case at the earliest possible time, having regards to the nature of accusation and the punishment prescribed for the same. His prayer for granting but stands rejected. Now, my lord, thereafter, my lord, I'll just take the objection, my lord. The objection recently the NCB has filed, my lord. That is 22/8, my lord. 22/8/2024, my lord. My lord, kindly directly come to para 9, page 53, my lord.
So, what is your point in this page number 49?
Page number 49 was that, my lord, this honorable court was of the view that the trial should move at a pace, my lord. Since the acquisition, my lord, those are there because this petitioner before your lordship is only a handyman. That I show from the seizure list also, my lord. Now, my lord, a separate captivity was made in the vehicle, my lord. Where from, my lord, this ganja was recovered. So my lord, I being the handyman, because the civil list itself says that the owner of the vehicle was also there. Thereafter, the driver was also there. Now, my lord, we are only laborers. We are assisting, my lord. We are cooking. We are changing the tires and everything people are doing. But my lord, that cannot be said that we have been there in concise position of that. That apart, my lord, 21 liberty is there, my lord. 3 years, 54 days, my lord. Now, this honorable court, my lord, says recent judgments, my lord. I'll say, show some of the recent judgments of the Supreme Court as well as our High Court, my lord, wherein they say that in remorse time also there is no possibility that they can conclude the trial, my lord. In view of that only. Now, only page 53, para 9, their objection, my lord. My lord, kindly see that, my lord. Page 53, para 9.
Yes.
My lord, para 9, my lord. That with regards to the contention made by the accused petitioner in para 9, the answering department begs to state that keeping in mind the rights of the accused, the prosecution is making best efforts to complete/conclude the trial at TLS, and in order to avoid incarceration of the accused person, the Honorable Additional Session and District Court, Rangia, has splitted up the case in respect of the arrested accused person Gautam Rai, accused Sahib Sahani, and accused Manish Kumar from absconding K.A. Jonathan, son of so-and-so, on our request, followed by framing of charge and commencement of trial. Considering the gravity of the offence committed by the accused petitioner, granting the bail at the stage of the trial would be a travesty of the justice, my lord. No witness examined, nothing done, my lord. Last 2 years, I'm there languishing in jail, my lord. Now, my lord, I'll place some of the judgments of the Supreme Court and our High Court judgments, my lord. Because, my lord, Article 21 liberty is curtailed. My lord, 3 years. By this time, my lord, the Lordship's order was on 11/11, my lord. Now, this is the latest, my lord. Kindly see the affidavit they have sweared on, my lord, page 56, my lord, 22 August 2024.
Yes.
Page 56, my lord, the affidavit swear by the intelligence officer, Narcotics Control Bureau, my lord, on 22nd of August 2024. This is the latest stage, my lord. Nothing has proceeded, my lord. Now, well, first, my lord, I'll place the judgment of my lord, first I'm relying on Sariful Islam, my lord. The first, I place certain judgments, my lord. I place certain judgments, my lord. First one is Sariful Islam, my lord. Sariful Islam, my lord. This is by 3 judges bench of the Honorable Supreme Court. My para 2, my lord. Taking into consideration the fact that a petitioner is reported to be in custody since 27/1/2021 and has suffered date 22/08/04 incarceration reasons for over, next page, my lord, for over 1 year, 6 months, and there being no likelihood of completion of trial in the near future, which fact cannot be
Mr.
controverted.
Tewari,
Yes, my lord.
now tell me, can we read this as a precedent?
My lord, in view of the concurrent orders of this honorable court, my lord, concurrent bench of this honorable court, my lord, I then take, my lord, to Tahir Ali's, my lord, recent order passed by Honorable Justice, my lord, Vidul Kumar Kolita on 26/6/2024, my lord. My lord, bail application number 556, my lord. Bail application number 556/2024, my lord. My lord, directly come to internal page 5, my lord, para 12 onwards, my lord. I have considered the submission made by the learned counsel for both sides as well as perused the materials available on record, including the scanned copy of the case record of special NDPS case number so and so. Honorable Supreme Court in so and so observed that the grant of bail on the ground of undue delay in trial cannot be said to be fettered by section 37 of the NDPS Act. The FX court in Ravi Prakash versus so and so, wherein it has been observed by the office court that the prolonged incarceration generally mutilates against the most precious fundamental rights guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under section.
Now tell me whether Ravi Prakash versus State of Orissa also can be read as a precedent.
As a precedent, those can be read out because in fact, my lord, the liberty, once the question of liberty comes under 21, my lord, then these judgments can be relied, my lord. Because a long incarceration, my lord, brings on the well, effectum of Article 21 to the accused person.
Before this judgment also, there is one judgment of 3 judgments of Supreme Court.
Yes, my lord.
That judgment has not been taken into account in the case of Ravi Prakash versus State of Orissa.
My lord, all thereafter, my lord, this,
And what would be the precedent? You go through the judgment of this Pranoy Setri versus National Insurance Company Limited.
my lord,
Their doctrinal precedent has been laid down by constitutional bench of the Supreme Court.
yes, correct, my lord.
Thereafter, you submit before this court that whether we can read Ravi Prakash versus State of Orissa as well as Muslim Mandal as precedent.
That's correct, my lord. I can understand, my lord. But my lord,
Then,
my lord,
if that is the legal proposition, then can we read this as judgment as precedent? Can we bound to follow this?
no, my lord, this court is not bound to follow because the as far as my lord, my understanding goes, my lord, bail is purely a discretionary power of the honorable court, my lord.
That's
Now,
all
my
right.
lord would see the case records, my lord would feel appropriate from the facts and circumstances.
Now,
of the
now
matter
you
of
tell
record,
me
my lord would appreciate.
at what stage the case is pending?
My lord, at the stage of my lord, evidence, my lord,
Evidence.
evidence.
How many witnesses have been cited in the
Okay.
search?
One witness, my lord, scientific officer.
Examine.
Only scientific officer, my lord. There are altogether 9 witnesses, my lord.
When the charge was framed,
My lord, the charges were my lord, I don't have the last charges framed, but my lord, the charges were framed way back in 2021 itself, my lord. 2021. Yes, my lord.
Yeah, yes, madam. When charge was framed,
Lordship, case record is necessary, Lordship.
case record is here, but you were there to assist the court. Have you gone to the case record?
Lordship, allow us some time, Lordship. I will go through the case record.
My lord, my lord, order says, my lord, the page 49, my lord, on 23/12/2021, my lord, charges were framed, my lord.
26?
23/12/2021. That's my, in your lordship's earlier order, my lord, on 11/11, my lord,
26/12?
23/12, my lord, 23.
But Mr. Tiwari, office note indicates that the case record has also not been received from the trial court.
Then in that case, my lord, Monday or Tuesday, my any day.
On bail hearing on 20 Lord Friday. On 20th September, Friday,
Sorted.
then on 18th. Wednesday.
Heard Mr. Tiwari, learned counsel for the accused, and what is your name?
And Kakoti.
And Kapote, Learned Counsel, appearing on behalf of Mr. S.C. Kayal, Learned Counsel for the Learned Standing Counsel for the NCB. After hearing of Mr. Tiwari, Learned Counsel for the accused, it has come to the notice of the court that the scanned copy of the record as well as the up-to-date status report has not been received. In view of office note dated 14/9/2024, accordingly, it is provided that SSL release the matter on
18th September.
18 September. And also send reminder to the learned trial court for transmitting the scanned copy of the record along with the status report forthwith.
I'm deeply
They
obliged.
want to take it back?
My lord, to keep it on record. Deeply obliged, Your Lordship.
Item number 4.
In this case, CD was called for, my lord.
CD.
My lord,
CD.
CD was called for.
CD
Already
received.
called for.
Lordship, CD is here, Lordship. CD is received, Lordship.
Received.
CD is here, Lordship, but the thing is, Lordship, the last updated request, CD has not been updated, Lordship. Because the last note is of, Lordship, the month of May, Lordship. So if Lordship allows me a short date time, Lordship, we can update the CD, Lordship. Earlier, it was rejected twice, Lordship.
This is second application.
Third, Lordship.
Third application. The learned heard Mr. Rahman,
M. Rahman.
learned counsel for the applicant. And also heard Mr. So-and-so, learned additional PP. The learned additional PP submits that he has received the case diary, but the same has not yet been updated. And accordingly, he pressed for short date. The press for some time to produce the updated case diary before this court fair is accordingly allowed. Rest shall list the matter
On 25th September.
25th.
From Lakhimpur, Lordship.
In the event of failing to produce the updated CD on that day, the court will proceed to hear and dispose of this application without producing the same case diary.
Item number 5, matters for orders.
May it please your lordship. Lordship, kindly peruse office note dated 9/9/2024. There is an enquiry report. Your Lordship.
No, that's it. No, but it's a what color number file on 15 of this, and 29.
So whether the certified copies are available with any of the party,
Your lordship, we are having some of the records.
some of the records.
Yes, but not all of them.
The claim petition is available
Petition and
Written statement.
Evidence in affidavit, those documents.
and the judgment.
Judgment also we have.
Speak wishes of the three wishes. Okay. At the time we are not present. Nice day, nice day. Thank you, you are not present.
So, as per inquiry report, the High Court has not received the record from the Commissioner's office.
Record record may be called for them.
No, according to them, they have already transmitted the same to the High Court. They have produced one letter also.
Record is.
But as per Jasper section report, it is not received by the High Court. So what to do then?
Lordship, in that case, we'll provide whatever we have.
Pardon?
Whatever, in that case, your Lordship, will provide whatever records we are having before your Lordship.
Along with us also.
Okay.
Along with us also.
Heard Mr. S. Dotto, Learned Counsel for the appellant, and Madam Devi, Learned Counsel for the respondent.
Respondent number 1.
Respondent number 1.
A Bora for respondent number 2.
Respondent number 2. Person to order of this court dated 16/8/2024. The Register Judicial of this court has submitted one inquiry report in respect of the receipt of LCR of WC case number 14 of 2009. The result of the report indicates that the record of WC case number 14 of 2009 has not been received by the registry of this court. In view of above, it is provided that at this instance, Mr. Dotto, Learned Counsel for the appellant, submits that he has some of the copies of the record with him. And he plays for granting him permission to submit the same before this court. Here is accordingly allowed Mr. Dotto shall furnish the records, copy of the records available with him for next date, and also furnish a copy of the same well in advance to Ms. Devi, Learned Counsel for the respondent number 1, and Ms. Bora to the respondent number 2. List the matter after vacation.
Okay, your Lordship. Much appreciated.
We are fixing a date because it is 2012 matter.
Yes, man, they're very old.
Yes.
25th October.
Okay,
Yes.
much appreciated.
Pass the bless.
Item number 6.
As per office note, my lord, LCR already received, my lord. A file also IA, my lord, so stay of the execution, stay of the order, my lord. Because my lord, title suit is regarding movable property, truck, my lord. And truck is, my lord, after accident, my lord, it is now, my lord, on garage, my lord, since January 2023, my lord. If the, my lord,
So,
order is, my lord,
LCR has been received.
received, my lord.
So matter is ready for hearing. So we can fix it that then finally dispose of the entire matter. Heard Mr. K.R. Patgiri, Learned Counsel for the appellant, and Mr. B.J. Mukherjee, Learned Counsel for the respondent number 1 and 2. It is submitted at the bar that service completed, and the LCR has also been ready when I receipt, and the matter is ready for hearing. And accordingly, it is contended that a date may be fixed for hearing of the entire matter. When No, এইটো এটা urgency আছে।
Before puja vacation, my lord.
Before not possible. Immediately after reopening.
7 November.
My lord.
No, no. Sorry. তার আগত। 24th.
Obliged.
Item 7.
Yeah, please, your turn. What a method for time being notes. My senior is in leg in course number 10.
Who is this senior?
Mr. Edson Kamali notes.
Wait for a while then. Let her senior come.
Blends.
Item number 8 by VC Mode. May please, Lord, in this case, my lord, actually, I will take a little time, my lord, like on the last occasion, my lord, I could place there are two decisions of the Supreme Court, my lord. On the last occasion, my lord, I could not produce there are two decisions of the Supreme Court, my lord, with regard to the order 41 rule 17, my lord. The first appellate court, my lord, in absence of the appellant, he heard the appeal, my lord, and dismiss the appeal, my lord, in absence of the appellant, my lord. That action of the first appellate court is illegal, apparently, my lord, not sustainable in the eye of law, my lord. For that, actually, I draw your lordship attention to the provisions as laid down under order 41 rule 17, my lord. There is a mandatory provisions, my lord.
Order 41 rule.
Rule 17, my lord. May I read, my lord?
Yes.
Dismissal of appeal for appellant's default, where on the day fixed or any other day to which the hearing may be adjourned, the appellant does not appear when the appeal is called on for hearing, the court may make an order that the appeal be dismissed, my lord. This subsequently, this may that was subsequently, it was, my lord, by an amendment, my lord, that this explanation, my lord. Nothing in this sub rule shall be construed as empowering the court to dismiss the appeal on merit, my lord.
Yes.
How we can dismiss my appeal in my absence, my lord, after hearing the respondent only, my lord.
My lord, I agree to that effect, my lord. It may be remanded back, my lord. This is a error which has been done by the first appellate court.
Yes, Mr. Das, any objection to his suggestion?
That is a law, my lord.
Only one prayer, since the suit of 94, appeal of 2012, a date may be fixed before the learned court below for hearing of the matter where both the parties appear, my lord. Suit is of 94. That was an error committed by the first appellate court. I have to agree to that fact, my lord. Because the law is clear, my lord. Judgments are also there.
The other law, I may not practice, my lord. The order 41 rule 31, my lord. The judgment is not in conformity with the provisions as laid down under order 41 rule 31, my lord. On that account, also the matter is to be demanded back to the first appellate court, my lord.
Okay, we'll pass the next. For which?
For hearing,
For hearing before the first appellate court. Trial court.
No, first appellate court, my lord. Matter will go to the first appellate court, my lord.
No. First appellate court, not the trial court.
First appellate court.
Yes.
21st October is a Monday. It can be done.
21st of October. Okay.
Monday.
Okay, 21st of October.
Obliged to your lordship.
Okay.
Item. Obliged. Item 9. Item 9, hearing matter.
It's a long pending case, my lord, RSA of 13. Actually,
You
my
are-
lord,
you are for
plainly,
respondent.
I am for respondent. Appellant side is that my lord, name has not shown, my lord, the in case, my lord, earlier SC Kyle, my lord, in order 18 to 14. While my lord, substantial questionable was framed and admitted. It's SC Kyle. I rang him, my lord, in morning. But
Today.
By showing his name, it may be. Name of the appellant's counsel has not been shown in the equal list, my lord.
Yes.
So may I pray that by showing the name of SC Kyle, it may be listed any next week or.
No, the question is whether he is still the council or not.
that is, he is to answer, my lord. He is to
Okay,
say before the court.
Okay, let him come. Inform him, COVID.
Yes, my lord. Timing.
Timing. After some time, then let Mr. Kyle come.
Yes, my lord. Also.
Item 11.
Lordship, she is in court number 15. I may be allowed to call her, your lordship. She will do the matter,
Okay.
your lordship. After something.
Lordship may take the matter after some time. My
After?
senior- After some time. My
Okay.
senior is on legs.
Okay.
Item 12 and 13.
Lordship may take up the testamentary case 8 of 16 first. Because that is the case by which my application for grant of probate has been rejected, Lordship. That will cover that will be the counter to the what succession has been granted to the respondent. That will counter argument in both the cases. One is against my rejection of that grant of probate, and the other is the succession granted to the respondent, Lordship. So if I had a petition for grant of succession, that was granted to the so both of the order has been challenged, Lordship, in separate appeal, Lordship. So if your Lordship take up the testamentary case first, that will cover my argument in both the cases, Lordship.
Testamentary case number 8.
8, Lordship. Now the appellant case was that on 3/3/2004, a will was executed by the testator. And after he expired on 22/8/16, I applied for grant of probate, and that was contested by and that was rejected on the ground that I am a second wife, which is irrelevant because bequest can be given to a stranger also. The other is that their suspicion circumstances have been stated, but that has not proved that influence was that never was proved. If they allege that there was influence, it is a responsibility cast upon them to.
So admittedly, you were the second wife.
I am the second wife.
Yes.
And it is not that
So
she has not been given anything
your pair is dismissed by the court.
dismissed by the court. The probate court should be granted whether the will has been duly approved or not, execution has been duly proved or not. One attesting witness is enough as per section 68 of the Evidence Act. That I have done. The deed writer, I have produced the deed writer and also one attesting witness. So that has been
Then
rejected.
you have examined that witness?
Lordship.
You have examined that witness?
Lordship, we have examined. That
Then
is
why the court has rejected the,
Bapukon Talukdar and Khargeshwar Kolita. Khargeshwar Kolita is the deed writer.
why the court has
Lordship,
dismissed your
to
pair?
the judgment, Lordship. Page 22. Lordship, may come the issues and the discussion made, Lordship. Issues, Lordship, will find at page 27.
Yes.
These are the issues, Lord, that has been framed, and the discussion has been made from 28 owners. May I read from the discussion part, Lordship?
Yes.
Paragraph number 7. Prior to discussing the issues framed in the suit, what transpired from the petition and the objection by the opposite party, two main questions are involved which will decide the whole dispute in the case, and the two questions are whether the will in question was duly executed as required under the provision of Indian Evidence Act 1872 and the Indian Succession Act. Number two, whether the will in question surrounded by suspicious and created under unnatural circumstances warranting rejection of prayer for probate of the said will and for grant of letter of administration. It is the established law that the will has to be proved like any other document except as to the special requirement of attestation prescribed under Section 63 of the Indian Succession Act. But the requirement under Section 63C Indian Succession Act 1920 is to be complied. It requires that the will should be attested by 2 or more witnesses. Each of them has seen the testator's sign or affixes marked to the will, or has seen some other person sign the will in presence and the direction of the testator, or has received from a testator a personal acknowledgement of his signature or mark, or the signature of such other person, and each of the witness shall sign the will in presence of the testator. But it shall not be necessary that more than one witness be present at the same time, and no particular form of attestation shall be necessary. Now it is necessary to closely examine whether the said provision has been complied with the present case. The plaintiff petitioner Gitanjali Das, as per facts of the case, has stated that though the deceased Golab Das was married to the opposite party number 1 Srimati Reena Das and OP number 2, 3 and 4 are sons and daughter, and as they frequently misbehaved with him and treated him with cruelty and drove him out from the house, and he has compelled to live at Majgaon, Tezpur, and as such there is no one to look after him. He married the plaintiff Srimati Gitanjali Das on 4/2/2004 according to Hindu custom, and they live as husband and wife. It is also in her case that in 2006, Golab Das fell ill and he was taken to Vellore Apollo Hospital and was diagnosed as having cancer, and he expired on 22/8/2006 at Tezpur EMM Hospital. These facts have been argued by the Land Council in the written argument, and is also stated that after his Shraddha ceremony, when the plaintiff was cleaning her house and arranging the household articles, the plaintiff found a piece of writing in a box, and on reading the same, the plaintiff found the said paper to be will, which was executed by Justice Golab Das on 3/3/2004. That those persons who signed the will as witness on inquiry by the plaintiff told that Golab Das executed the will in their presence, where they have signed as witnesses. On the other hand, as per the written argument submitted by the Land Council of Defendant, Respondent Srimati Reena Das stated that the deceased married Gitanjali Das and was living with her at Tezpur in a rented house as husband and wife, and no marriage could be lawfully solemnized on 4/2/2004 or on any date according to Hindu rites and Hindu law. Hence, evidently, Srimati Gitanjali Das was living with the deceased as his concubine, who could never request this status of a legitimate wife under Hindu law. It is also stated that the deceased was living an adulterous life with Srimati Gitanjali Das at Tezpur and fell ill and ultimately died on 22/8/2006 at EMM Hospital, Tezpur, and his Shraddha was performed by his legitimate wife Srimati Reena Das and her children and village Pani Bhoral, and therefore no law Shraddha could be performed by a concubine Srimati Gitanjali Das under law. It is also falsely stated that the Shraddha ceremony, when the plaintiff was cleaning the house, arranging the household articles, she found a writing in a box, and on reading the same, she found the said paper to be a will, which was purportedly executed by the deceased on 3/3/2004, and that finding some signature as witnesses in the purported will on inquiry, the plaintiff learned that the purported will was executed by the deceased and attested by Sargesha Kalita, Krishna Roy, Romani Deka as witnesses, and the same was purportedly written by the scribe one Bapukon Takudar of Tezpur Toroni Samstha. That from the circumstances, it is evident that Golab Das was ill in the year 2004. Till his death, 2006. Now, where from his get this conclusion? No medical evidence is in the record, Lordship, from 2004. It's only transpired that he diagnosed with cancer only in 2006. May I proceed, Lordship? And so naturally could not come to Tezpur court and execute any will in presence of so-called witness at Tezpur Tarani Sansthan. The purported witness Krishna Roy and Romani Deka, though filed affidavit, they did not appear in the court for cross-examination, for which their evidence were expunged, which leads to grave out of suspicion as to the actually executing the purported will by deceased. On the other hand, going through evidence and the
cross-examination from the plaintiff petitioner Gitanjali Das, it is seen that she stated that she was present at the time of execution of the said will, which is contradictory to the petition or affidavit where she stated that she found the will written in a box where she is cleaning the house, and so suspicious arises regarding the actual execution of the will. The evidence of witnesses to the will, Sri Krishna Roy and Romani Deka, who did not appear in the court for cross-examination, led to the expunging of their evidence, so their evidence cannot be considered. As stated earlier, the law requires that the will should be attested by 2 or more witnesses who had seen the testator's sign or affixes mark. So the fact remains that the evidence of 2 witnesses of the will, namely Sri Krishna Roy and Romani Deka, cannot be considered while deciding the genuineness of the will. So the evidence of plaintiff Gitanjali Das, Khorgeshwar Kalita and Bapupon Talukdar, writer of the will, remains to be considered for coming to a conclusion whether the will was genuine or not. In the evidence of Sri Khorgeshwar Kalita, he has stated that the deceased Golab Das had on 2/3/2004 come to his shop in the evening and told him that he wanted to make a will and asked him to be a witness. And so the next day on 3/3/2004 at about 11 a.m., the deceased came to the Mohori Khana of the Tezpur court, and there the will was prepared and signed. He had also stated in the evidence that on that day only he came to know that Gitanjali Das was the second wife of Golab Das, as his earlier wife Reena Das has neglected to take care of him. On that day, another witness, Romani Deka, came to the Mohori Khana, and the Mohori Bapukon Talukdar prepared the will, and thereafter, being read out the content of the will, he put his signature on the will, and he also identified the signature of Bapukon Talukdar. He also deposed that thereafter Golab Das took the will and went in the scooter of Romani Deka. So in this evidence, the name of the witness Krishna has not come out. And as per the evidence, where he stated that Romani Deka has signed the will, is not understandable and creates doubt. In this course examination, he says that the shop of Romani Deka, the will was prepared, and their Gitanjali Das was also sitting. This portion is contradictory to the evidence of the petitioner plaintiff Gitanjali Das, who stated that thus he found the will while cleaning the house. This is a major contradiction and creates a doubt as to where and how the will was prepared and how the same was revealed. The argument of the learned counsel of the defendant respondent Srimati Reena Das that the will is a forged and fraudulent one bears some force in the believable and can be taken into consideration. In the evidence of Bapukon Talukdar, he has stated that he does not know whether on the day of the writing of the will, Gitanjali had come to his shop, and he also did not know the witness Romani Deka, Krishna Roy and Khorgeshwar Kalita prior to the making of the will. The evidence of Gitanjali Das in the light of discussion made above cannot be believed to be true and trustworthy, and that the will exhibits with every possibility of being a forged and fraudulent one, as it is an unregistered one. Now, Lordship, will is not compulsorily registrable, Lordship. Simply because it is not registered, that the conclusion has been drawn. In this context, the reference can be made to 2001 so and so, where the Honorable High Court has held that the will cannot be probated if it is surrounded by suspicious circumstances. And in our case, the petitioner Gitanjali Das is said to have been given the will by the Justice Golab Das, as he had looked after him during the last part of his life, though her evidence differs from her petition and affidavit regarding disclosure of the will. On the other hand, it is also the evidence that the deceased was suffering from cancer, and it was averred that it was not possible for him to come to the court and prepare the will. This part also to be considered. So the discussion made above, the petitioner Gitanjali Das has given two versions finding the will while cleaning the house, and also her another version that she had come with the deceased testator along with the witnesses to the court on the day when the will was prepared and signed, creates suspicion and is hard to believe her evidence and is not trustworthy and credible. The Honorable Supreme Court in so and so has held that the court of probate is only concerned with the question whether the will document put forward is the last will and testament of a deceased person was fully executed and attested in accordance with the law, and whether at the time of such execution the testator had sound disposing mind. These facts have not been proved by the petitioner Gitanjali Das. The learned counsel for the petition has referred to a judgment in so and so where it has been held that the relationship has nothing to do with the matter of probate, of will, of letter of administration. Also, in the point of undue influence, the Bombay High Court has held that the burden of proof on undue influence lies heavily on the party who claims it. In AIR so and so and Calcutta High Court so and so, it has been held that the Mere physical presence of the legatee at the time of execution of the will without anything more in no such circumstance so as to arrest suspicion of a probate. In our instant case, the will itself is doubtful regarding its circumstances of execution. Moreover, the petitioner Gitanjali Das is said to be his second wife, and under the provision of Hindu law, the second wife cannot be said to be a legal wife, though their will is made. The said provision of law will not apply. However, in the above suspicious circumstances regarding execution of the will, the petitioner has not proved that the said will, which is also an unregistered one, was executed in her favor by the deceased. Her relation with the deceased has created suspicion in the light of the circumstances stated above, to the voluntary character of the document, and in the context reference to a decision can be made of so and so, where it has been held that the fact that the will was genuine and made is sound mind is to be proved. I therefore find that from the testimony of the witnesses, the will of this case cannot be considered as the last will, as it is still doubtful and suspicious. The plaintiff petitioner has admitted in her cross-action that there cannot be more than one marriage during the lifetime of the other wife, and she admitted that she did not acquire the status of wife under the law. After considering the entire matter in the light of the aforesaid discussion, I am of the opinion in my considered view, the execution though is doubtful and is shrouded with mystery and suspicious circumstances. It is therefore held that the mere possibility that since the deceased was living with his second wife in a rented house and was serving as a development officer of Oriental Insurance Company Limited, Tezpur branch, and living with the petitioner Gitanjali Das without any lawful relation, and the said will found under suspicious circumstances cannot be held to have taken place in a lawful, true and valid manner, hence probate of letter answer cannot be allowed. According to this probate application number so and so is rejected. Now, Lordship, my status as a second wife is immaterial because you can be even to a stranger. Now, Lordship, what the evidence has come out, Lordship, I just wrote through express from the evidence, Lordship. This Khargeswar Kalita who is the deed writer. In his cross, Lordship is the record, Lordship.
Yes.
May I read slowly, Lordship? Wilcon likhi pori jo not a Golab Das sohi kore. In cross he is stating, Lordship. Khargeswar Talukdar, he is PW, Lordship, PW3. May I read the cross part, Lordship?
एक minute. Yes.
Golab Dase তেওঁৰ বিশ্বনাথ চাৰিআলিত বুলি তেওঁৰ ঘৰ বিশ্বনাথ চাৰিআলিত বুলি কৈছিল। উইল লিখা দিনাখন মই জানিব পাৰো যে গোলাপ দাস আৰু এগৰাকী পত্নী আছে। উইল লিখিব দিনাৰ গোলাপ দাসে মহাভৈৰৱ মোৰ দোকানত মোক কৈছিল নে তেওঁ দুগৰাকী পত্নী আৰু তেওঁলোকক মাজত তেওঁৰ সম্পত্তি সম্পৰ্কে বিবাদ যে নোহোৱাৰ বাবে উইল কৰিব বিচাৰিছে,
যাতে বিবাদ হ'ব নোৱাৰে
তাৰ বাবে উইল কৰিব বিচাৰিছে। ৰমণী ডেকাৰ দোকানত মোৰ লগতে উইল কৰোতে গোলাপ দাসে গীতাঞ্জলি মই আৰু ৰমণী ডেকা আহিছিলো। উইলখন 3/3/2004 তাৰিখে তেজপুৰৰ মহৰী থানাত হৈছিল। মহৰী বাপুকন তালুকদাৰে এক্সিবিট 1 উইলখন লিখিছিল। লিখতে পিছত কয় মই আৰু ৰমণী বাইদেউ
বাইকত আহিছিল। উইলৰ লিখা পঢ়ি শুনোৱাত গোলাপ দাসে চহী কৰে, মই আৰু ৰমণীয়ে চহী কৰো। উইল লিখা সময়ত কৃষ্ণা ৰয় নামৰ এজনী মানুহ আছিল, মই তেওঁক চিনি নাপাওঁ।
So he has proved that he right after that he stated what he has been written and thereafter the testator put his signature. That part has been proved. And that Romani was there, Lordship. And in his presence, that was signed, Lordship. That aspect has been proved.
No, you come to the subsequent cross-examination.
Lordship. Pardon, Lordship.
Come to the subsequent cross-examination of this Professor Kolita.
Pardon, Lordship.
Subsequent part of cross-examination of
Subsequent part.
Professor Kolita.
উইল কৰা সময়ত গোলাপ দাস গীতাঞ্জলি লগত দৰং কলেজৰ ওচৰত বসবাস কৰিছিল। মই থাকো বৰুৱা চুবুৰীত। ৰমণী ডেকা আৰু কৃষ্ণা ৰয়ক মই আজি আদালতত দেখা নাই। এই উইলৰ দ্বাৰা গীতাঞ্জলি গোলাপ দাসে কি কি সম্পত্তি দিলে মই ক'ব নোৱাৰো। সত্য নহয় যে গোলাপ দাসে উইলত চহী কৰোঁতে মোক ৰমণী ডেকা আৰু কৃষ্ণা ৰয়ক সন্মুখত চহী কৰা নাই। সত্য নহয় যে সেইবাবে ৰমণী বা কৃষ্ণা ৰয় আজি আদালতত অহা নাই। তেওঁলোকক কিয় অহা নাই মই নাজানো। সত্য নহয় যে গীতাঞ্জলিৰ প্ৰৰোচনাত পৰি উপায়বিহীন হৈ গোলাপ দাসে এই উইলখন কৰিছিল। সত্য নহয় যে আমি সাক্ষীগণে গোলাপ দাসৰ সন্মুখত উইলত চহী কৰা নাই। Now, what the respondent said in her evidence, Lordship, that is also important. First, we may take up the evidence of Reena Das as a DW.
DW1.
DW.
Yes.
I'll just read down the cross part, Lordship. More Samir now. First, you responded. Married, Lordship. মোৰ স্বামীৰ নাম গোলাপ দাস। 1979 চনত আমাৰ বিয়া হৈছিল। বিয়াৰ সময়ত স্বামীক চাকৰি নাছিল, অন্য কাম কৰি আছিল। সেই সময়ত আমি আমাৰ ঘৰ বিশ্বনাথ মৌজাৰ পানী ভঁৰাল গাঁৱত আছিলো। সেইটো মোৰ স্বামীৰ ঘৰ আছিল। মোৰ ল'ৰা দুটা, ছোৱালী এজনী। সিহঁতৰ জন্ম পানী ভঁৰাল গাঁৱত হৈছিল। মোৰ স্বামী 1982 চনত চাকৰিত সোমাইছিল আৰু মৃত্যুৰ সময়লৈকে তেওঁ চাকৰি কৰি আছিল। তেখেত অৰিয়েণ্টেল ইঞ্চুৰেঞ্চ কোম্পানীত চাকৰি কৰিছিল। প্ৰথমে বিশ্বনাথ চাৰিআলিত চাকৰি কৰিছিল, পিছত বদলি হৈ তেজপুৰত কৰে। সেই সময়ত তেওঁ পানী ভঁৰাল ঘৰতে আছিল। 1987 চনলৈকে তেওঁ পানী ভঁৰালত থাকে। তাৰ পিছত তেওঁ বিশ্বনাথ চাৰিআলি বাম গাঁৱলৈ আহে। বাম গাঁৱত সৰু ল'ৰাটো জন্ম হৈছিল। 2004 চনত তেখেতৰ তেজপুৰলৈ আহে আৰু তেজপুৰত থাকিবলৈ ল'লে। 2006 চনৰ 22 আগষ্টত মোৰ স্বামীৰ মৃত্যু হৈছে। মোৰ সৰু ল'ৰাটো জন্ম 1988 চনত হৈছিল। তাৰ নাম আদিত্য দাস। 1987 চনৰ পৰা মোৰ স্বামী তেজপুৰত আছিল। সেই মাজে সময়ে পানী ভঁৰাল গাঁৱলৈ গৈছিল। সত্য নহয় যে so he is a since 1987 he is a Tezpur, that has been come out that he has not a good relation and visiting our house at Pani Bhoral, Lordship. সত্য নহয় যে মোৰ সৰু ল'ৰাৰ জন্মৰ এবছৰ মানৰ পিছত পৰা মই আৰু মোৰ পৰিয়ালে স্বামীক কৰিবলৈ ললো।
অৱজ্ঞা
অৱজ্ঞা কৰিবলৈ ললো আৰু সেইবাবে তেওঁ তেজপুৰত থাকিবলৈ ললে আৰু পানী ভঁৰাল গাঁৱলৈ মাজে মাজে আহিবলৈ বাদ দিলে। পানী ভঁৰালত থাকোতে মোৰ স্বামীৰ অলপ বেমাৰ হৈছিল। সৰু ল'ৰাৰ জন্মৰ 2 বছৰ আগতে আমি বামগাঁৱলৈ যাওঁ। বামগাঁৱৰ আমি ভাড়া ঘৰত আছিলো। পানী ভঁৰালৰ পৰা বামগাঁৱৰ দূৰত্ব 2 কিলোমিটাৰ মান হয়। সত্য নহয় যে মই মোৰ সৰু পৰিয়ালৰ লগত বিভিন্ন কাৰণত মোৰ মনোমালিন্য হোৱাত স্বামীয়ে মোক আনি বামগাঁৱলৈ থাকিবলৈ ললে। পানী ভঁৰালৰ পৰা বিশ্বনাথ চাৰিআলি দূৰ মাত্ৰ 1 কিলোমিটাৰ, স্কুললৈ 1 কিলোমিটাৰ মান হয়। পানী ভঁৰালত বা বামগাঁৱতে ল'ৰা ছোৱালী পঢ়াৰ বেছি সুবিধা, সেইবাবে মই বামগাঁৱত থাকিবলৈ লৈছিলো। মই নিজে কোনো চাকৰি নকৰো, মোৰ কোনো নিজস্ব ইনকাম নাই। বামগাঁৱত যিটো ঘৰত আমি ভাড়াত আছিলো, স্বামীৰ মৃত্যুৰ পিছত তেওঁ LIC পৰা পইচাৰে সেই ঘৰটো কিনি ললো। স্বামীয়ে মোৰ নামত পলিচি কৰি দিছিল, সেইটো পলিচি টকা কিনিছিলো। সেই পলিচিৰ পৰা 9 লাখৰ ওপৰত টকা পাইছিলো। ঘৰটো 4,60,000 টকাত কিনিছিলো। সত্য নহয় যে মোৰ স্বামীক দুৰ্ব্যৱহাৰ কৰিছিলো, সেইবাবে তেওঁ বামগাঁৱত ঘৰলৈ যোৱাত দিব খোজা নাই আৰু মই বা মোৰ ল'ৰা ছোৱালীক তেওঁৰ তেজপুৰ ঘৰলৈ অহা নাই। তেওঁ মাজে মাজে আমালৈ টকা পঠিয়াইছিল। সত্য নহয় যে মোৰ স্বামীৰ অসুখ হোৱাত চোৱা চিতা কৰিবলৈ কোনো মানুহ নথকা বাবে গীতাঞ্জলি দাসক তেওঁ দ্বিতীয় পত্নী হিচাপে বিয়া কৰাইছিল। মই বামগাঁৱত আছিলো, তেজপুৰত থকা নাছিলো স্থায়ীভাৱে। তেওঁক বেমাৰ হোৱাৰ খবৰ দিলে ল'ৰা ছোৱালী আহিছিল, মই অহা নাই। So Lordship, she is not in a good relation that is established. After he fell ill, she never visited, that she herself admits. তেওঁ গীতাঞ্জলিয়ে শুশ্ৰূষা কৰিছিল। Next line is also important, Lordship. সত্য নহয় যে গীতাঞ্জলি মোৰ স্বামীক দ্বিতীয় পত্নী হিচাপে ৰাখিছিল। গীতাঞ্জলিৰ ভাত পানী ৰন্ধাৰ বাবে কাম কৰা হিচাপে ৰাখিছিল। মোৰ স্বামীয়ে 3 মাৰ্চ 2004 নামত যদি কিবা উইল কৰিছিল তেন্তে মই নাজানো। সত্য নহয় যে মোৰ স্বামীয়ে তেওঁৰ অস্থাৱৰ যিকোনো সম্পত্তি গীতাঞ্জলি দি থৈ গৈছিল। মই ছাকচেছন চাৰ্টিফিকেটৰ কেছ দিয়াত পিছতে গম পাওঁ এই উইলৰ কথা। মোৰ স্বামী আৰু মোৰ মাজত লাভ মেৰেজ হৈছিল। বিয়াৰ আগতে মোৰ ঘৰ দগাঁৱত আছিল। সত্য নহয় যে মই মোৰ স্বামীক বিয়াৰ পিছৰ পৰাহে জানো বুলি আনটো গোচৰত কৈছো। মোৰ স্বামীক পৰিয়ালৰ দ্বিতীয় বিবাহ অৰ্থাৎ দ্বিতীয় পত্নী নোহোৱাৰ ব্যৱস্থা নাই, এই কথা মই জানো। সত্য নহয় যে মই কৰা ছাকচেছনৰ গোচৰত কাৰণত স্বামীক পৰিয়ালত কোনো ধৰণে May I read this, Lordship?
Yes.
If a document is required by law to be attested, it shall not be used as evidence until one attesting witnesses at least has been called for the purpose of proving his execution, if there has been an attesting witness alive and subject to the process of the court and capable of giving evidence. Provided that it shall not be necessary to call an attesting witness if proof of the execution of any document, not being a will, which has been registered in accordance with the provision of the Indian Legislation Act, unless its execution by the person by whom it purposed to have been executed specifically denied. So, Lordship, the law requires that one attesting witness has to be examined. That has done through Lordship. This Bapukon Talukdar, Lordship.
He is the scribe of the matter.
Lordship, Khargeshwar will be Khargeshwar Kolita, Lordship. Khargeshwar, I'm sorry, Lordship. Khargeshwar Kolita. Now, Lordship may take up the citation which I am relying, Lordship. First is Lordship 2007 1 GLT, page 345. Party's name is Dilip Datta Bhaumik and others versus Meera Datta Bhaumik. Lordship, I'm relying on paragraph 121 onwards.
Yes.
May I read, Lordship? The first duty of the court is to take note of setting in which the will was made by the testator. Needless to say that in construing a will, all important consideration is the ascertainment and effectuation of the testamentary intention. The patience and prudence and even obsession of the testator have to be taken into account. His prudence against a near relative by itself, no ground for invalidating his will, even if such prudence is ill-founded and or unreasonable. The testator is at liberty to omit his relation or reason that may be bad, and this will not deprive him from testamentary power. As the wills are too frequently made by the sick and dying, the degree of understanding and memory which the law requires is such as may be reasonably expected from person in that condition. Therefore, it is wrong to suppose that those qualities of mind should be possessed by the testator in the highest degree, position, or to the same extent as before the illness in order to enable him to validly make this will. Section 59 of the Indian Succession Act requires that the testator should have a sound mind. The sound mind referred to does not mean that the testator should have his mental faculty in their fullest vigor, but he should have the capacity to understand the nature of the property, memory to remember and relation, and person normally having claims on his bounty and all has also a judgment. As observed by his lordship Privy Council in so and so, the fact that the testator was unwell when they executed the will is a long way from saying that he had no testamentary capacity. The testator does not have to be found to be a perfect state of health of mind, health to have his will declared valid. It is sufficient to prove that he is able to outline the manner in which his estate was to be disposed of. Now, paragraph 124, Lordship. The burden of proof of undue influence is not discharged by mere establishing that a person has the power unduly to overpower the will of the testator. It must be shown that in the particular case, the power was exercised, and then it was by means of exercising of that power which the will was obtained. In the present case, no evidence has been adduced by the end. The burden of making the will by providing undue influence was definitely on the respondent who had miserably failed to discharges. Pausing for a moment, here, Lordship, no evidence has been laid that he was ill, producing any medical document, that he was not fit enough to execute the will. Paragraph 125, Lordship. Section 68 of the Evidence Act deals with the proof of execution of the document required by law to be attested. In the instant case, the execution of the will has been witnessed and attested by 3 witnesses, 2 of whom have been examined, and they have duly proved the execution of the will of the testator. In the cross-examination, nothing contradictory which can be stated to be immaterial effect would be extracted. As observed above, the illness, not even serious illness, would have invalidated a will. All that is required to lead evidence to the effect that the testator had a sound disposing mind, notwithstanding illness at the time of execution of the will. It is true that the profounder was ill and was under treatment, but it is clearly an evidence that he was the sound disposing mind and even furnished instruction to the learned advocate for preparation of the will. He could have even make alteration and changes in the will by his own handwriting. All this. A will is one of the most solemn documents. By it, a dead man entrusts to the living to carry out his wishes, and it is impossible that he can be called either to deny his signature or to explain the circumstances in which it has been executed. The content of the will have been quoted above. On a plain reading of the same, it is apparent that perfect form and the evidence of attesting witness has to be trusted. In the instant case, the testator was ill. However, the onus has been sufficiently discharged by proving of disposing mind, notwithstanding illness. Needless to say that a finding regarding testamentary capacity is one of the facts that evidence is recorded overwhelming to establish the factum of testamentary capacity of the testator. So, Lordship, in this case, Lordship, what has been stated, even I may be second, but that doesn't debar me from repeating. And that I was taking care of. Here's a bad relation that has come out. The next case, Lordship, I'm relying on 2008 supplementary JLT page 733. Party's name is Deepak Kumar Das versus Parvati Das. Here the testator wanted to give to her one of his sister-in-law, because of there being some relation, that has been, what is the reason that is
No,
discussed?
but Mr. Chakraborty,
Lordship.
so why the trial court has rejected, dismissed the petition?
One of the reason was that I'm a second wife. Second is that my contradictory in the sense that I was present at the time of execution of the will, but I stated that I have found it in a box, iron box, where cleaning and all. That doesn't the matter, immaterial, because it.
No, in which part of the judgment it is reflected?
Lordship.
Oh, this paragraph number 20 is relevant, where it is opined that will is doubtful and is shrouded in mystery and suspicious
Yes,
circumstances.
the reason, Lordship, is that trial court has discussed, Lordship.
Page 35, your lordship will find that portion.
Pardon?
Page 35.
35.
35. Regarding these two versions of the petition.
Which paragraph?
Page 35, it starts from the beginning. Okay. Running page 35 and internal page 14 of the judgment.
Yes.
Lordship, at paragraph 11 is this on the contradiction of founding the will. Paragraph 11. Paragraph 11 of the judgment at page 32. On the other hand, going through the evidence and the cross-examination from the plaintiff petitioner Gitanjali Das, it is seen that she stated that she was present at the time of execution of the said will, which is contradictory to the petition on affidavit wherein she stated that she found the will written in a box while she was cleaning the house. This is one of the circumstances that led to the conclusion drawn by the.
So, paragraph number 10.
11, Lordship.
11.
Page 32.
So, the burden to remove the suspicious circumstances is upon you.
I discharged my preliminary part by producing one of the witnesses and the scriber of the
Hmm.
deed. Then the decision which I have just referred, there stated that the burden shifted to the other side.
Hmm.
That is what has been stated at paragraph 24, 124. That is 2007 1 GLT,
Hmm.
paragraph 124.
Hmm.
It is heavily on the burden shifts to them when they allege that it was under undue circumstances. That is has been stated in paragraph 124. May I just read that once more, Lordship. The burden of proof of undue influence is not discharged by mere establishing that a person has the power unduly to overpower the will of the testator. It must be shown that in the particular case, the power was exercised and that it was by means of that exercise of that power with the will was obtained. So they have to, more than mere alleging, they have to show that it was exercised and the will was obtained under such circumstances. Lordship, the next case, Lordship, I was referring to, Lordship. 2008 supplementary GLT page 733, relevant paragraph are 10, Lordship, 10, 11, 12, 15 and 16. 10, your Lordship makes these describe about the provisions of law. Lordship may come to the paragraph 11.
Yes.
Honorable Mr. Justice S.B. Sinha in Benga Behera and another versus Rajokishore Nanda and others observed that it is now well settled that the requirement of the proof of execution of a will is the same as in the case of certain other documents, for example, gift or mortgage. The law requires that the proof of the execution of a will has to be attested at least by two witnesses. At least one attesting witness has to be examined to prove the execution and attestation of the will. Further, it is to be proved that the executant and had signed and or given his thumb impression in presence of at least two attesting witnesses, and the attesting witnesses had put their signature in presence of the executant. The apex court in Bhagatram and others reported in so and so held that a will has to be proved as required by the main part of the section 68 of the Evidence Act 1873, inasmuch as under provision to section 68, it shall not be necessary to call an attesting witness in a proof of execution of any document not being a will, whereas so and so read as. According to section 68 of the Evidence Act 1872, a document required by law to be attested, which is a will, it shall not be used as a piece until one attesting witness at least has called for the purpose of proving its execution, if available, to depose and amenable into the process of the court. The proviso inserted in section 68 by Act of 31 of 1926 dispense with the mandatory requirement calling an attesting witness in proof of execution of a document to which section 68 applies, if it has been registered in accordance with the provision of the Indian Registration Act 1908, unless his execution by this provision by whom it is purport to have been executed specifically denied. However, will is expected from the operation of the proviso. Will has to be proved as required by the main part of section 68. It is true that section 63 of the Indian Code does not specifically speak of codicils, and the omission has prompted the learned counsel of the appellant to argue that the applicability in this part may be spoke. So we may come to paragraph 17, Lordship. Made it. The apex court in Gurudev Kaur and others versus Kaki and others reported so and so held that the content of the will have to be appreciated in the context of his circumstance and not vis-a-vis the rules for intestate succession. Though court does not substitute its own opinion for what is the testator's what was the testator's the will to will or intention as the manifested from a reading of the written instrument paragraphs so and so are quoted here under. Judgment must administer law according to the provision of law. It is for the bounden duty of the judges to discern legislative intention in the process of adjudication. Justice administered according to the angel dreams and so that part may be skipped. The next quotation 79 para, that is it's a quotation from 79. If a will appears on the face of it have been duly executed and attested in accordance with the requirement of the statute, a presumption of due execution and attestance applied. So presumptions is in my favor if I can prove that it has been executed in the presence of one of the witnesses. Yet I have done, Lordship, through this Kyrgyzstan Kodita. Lordship, the last citation which I am relying is a 2004 GLT, page 306. Dullabh Chandra Bhattacharjee versus Atul Bhattakur. The relevant paragraph is 2005 GLT, page 306. Paragraph 33.
Mr. Chakraborty will come back after 5 minutes.
Citation I am relying, Lordship.
Pair number
Paragraph 33.
30.
3. May I read, Lordship?
Yes.
The said legal requirements were also reiterated by apex court in Daulat Ram, Meenakshi Mal, and Sridevi. In Sridevi case, the apex court has held that though honest to explain the suspicious circumstances on the propounder, but honest to establish the allegation of undue influence, fraud or coercion is on the persons who make such allegations. Proving either case should be one of the satisfaction of the prudent man, and when the will is found to be duly executed as required under the law, and propounder dispel the suspicious circumstances, if any, and when the person alleging undue influences, fraud or coercion failed to discharge his burden, the probate of the will has to be granted by the court. So nothing has been produced to prove that the undue influence was there. He was not mentally fit or whatever, maybe the sick person proving any medical evidence, any papers to that regard. Coupled with that, signature has not been disputed, but only stated that it was under undue influence. That is what's been stated. I have produced one witness and the scribe and Lordship. It is not that she has not been given anything. She has been given the Pani Bhoral land and also the LIC amount of 9 lakhs. That's I have been given only the retirement benefit and the land at Tezpur. That has been written in the will, Lordship.
Retirement benefit.
Retirement benefits and the land at Tezpur, Lordship. That's all, Lordship.
Retirement benefit including this
Yes,
pension.
Pension or perhaps, Lordship.
But the law in respect of pension is already well settled by
If she's
Supreme
made the
Court.
nominee, Lordship. If she's made the nominee, or that part will be taken care of in a different position, whether I'm entitled to pension or not.
Mm.
Probably pension is not a matter of fact here. We was serving in Oriental Insurance Company. So some retirement benefit.
Gratuity and maybe
Yes.
provident fund. Gratuity and provident fund. That part.
Question of pension may not arise in this case.
So that's all, Lordship.
Okay.
And this argument, if I succeed in the testamentary case, the other case that goes, Lordship. So submission will be the same, Lordship.
Okay.
Lordship.
May
Deeply
I
obliged.
please? My lord, I am appearing for the first wife respondent.
Yes.
But before dealing with this judgments cited by my learned senior friend and the propositions of law, my lord, one thing I would like to submit before this honorable court.
Mm.
That my lord, plaintiff or the petitioner has to stand on its own legs.
Mm.
He has to depict the facts of the case,
Mm.
and that facts has to be supported by the evidence adduced by the plaintiff or the petitioner.
Mm.
Now, my lord, your lordship may kindly come to the evidence on affidavit
Mm.
of PW1, which my learned friend has escaped. What she has stated in her evidence in chief on affidavit.
Yes.
Lordship has got it. Srimati Gitanjali Das.
Yes.
Well, Badinir Eknong Hakir Hopapapro. She is the petitioner herself.
Mm.
I am reading from the portion, paragraph 1. মই এই গোচৰৰ দৰখাস্তকাৰিনী হওঁ। মৃত গোলাপ দাসৰ মই বিবাহিতা পত্নী হওঁ। তেওঁ মোক 2004 ফেব্ৰুৱাৰী মাহৰ 4 তাৰিখে সামাজিক নিয়ম মতে বিশ্বনাথ চাৰিআলিৰ পৰা আনি তেজপুৰৰ ৰত্নপুৰ মাজগাঁৱত দুইজনৰ পৰিয়ালৰ সাক্ষাতত বিবাহ পাশত আবদ্ধ হয় আৰু তেতিয়াৰ পৰাই আমি দুয়ো স্বামী স্ত্ৰী হিচাপে তেজপুৰত বসবাস কৰিব আৰম্ভ কৰোঁ। Paragraph 2, মোৰ স্বামী মৃত গোলাপ দাসে ইঞ্চুৰেঞ্চ কোম্পানীত চাকৰি কৰিছিল আৰু চাকৰি সূত্ৰে মৃত্যুৰ আগলৈকে তেজপুৰ শাখাত কাৰ্যনিৰ্বাহ কৰি আছিল। Paragraph 3, মোৰ সৈতে বিবাহ পাশত আবদ্ধ হোৱাৰ আগতে মৃত গোলাপ দাস বিবাহিত আছিল আৰু তেওঁৰ পত্নীৰ উপৰিও দুজন ল'ৰা আৰু এগৰাকী ছোৱালী পিতৃ আছিল। কিন্তু তেওঁৰ প্ৰথমা পত্নী আৰু ল'ৰা ছোৱালীয়ে তেওঁক দুৰ্ব্যৱহাৰ কৰিছিল আৰু তেওঁক স্বামী তথা পিতৃৰ মৰ্যাদা দিয়া নাছিল আৰু কেতিয়াবা বিশ্বনাথ চাৰিআলি মাজগাঁৱত থকা তেওঁৰ ঘৰলৈ গ'লেও তেওঁক শাৰীৰিকভাৱে প্ৰহাৰ কৰিবলৈ খেদি আহিছিল। তেওঁ উক্ত ঘৰলৈ গ'লে প্ৰাণৰ শংকাত পৰিব বুলি উক্ত ঘৰলৈ যোৱাটো বন্ধ কৰিছিল আৰু সেয়ে চাকৰি সূত্ৰে বাহিৰে বাহিৰে আছিল। কিন্তু তেওঁৰ বয়স বাঢ়ি অহাৰ কাৰণে তেওঁক সেৱা শুশ্ৰূষা কৰা কোনো মানুহ নোহোৱা বাবে তেওঁ মোক পত্নী হিচাপে গ্ৰহণ কৰে আৰু ময়ো তেওঁক স্বামী হিচাপে সম্পূৰ্ণ সেৱা আগবঢ়াই মোৰ পত্নীৰ দায়িত্ব পালন কৰিছিলোঁ। মোৰ স্বামী গোলাপ দাস যোৱা ইংৰাজী 22/8/2006 তাৰিখে তেজপুৰৰ চয়েন্স হস্পিটেলত মৃত্যু হয়। মৃত্যুৰ কেইদিনমান আগতে অৰ্থাৎ জুলাই মাহৰ প্ৰথম সপ্তাহত তেওঁক চিকিৎসাৰ বাবে ভেলোৰৰ এপলো হস্পিটেললৈ নিয়া হৈছিল। তাত তেওঁ কেঞ্চাৰ ৰোগ হোৱা বুলি ধৰা পৰিছিল। তাৰ আগতে তেওঁ কোনো ধৰণৰ অসুখ নাছিল, তেওঁ স্বাভাৱিক জীৱন যাপন কৰিছিল। মোৰ স্বামীৰ মৃত্যুৰ পিছত তেওঁৰ শ্ৰাদ্ধ দি মই তেজপুৰৰ দৰং কলেজ ৰোডত থকা ভাড়া ঘৰত সম্পন্ন কৰোঁ শ্ৰাদ্ধৰ পিছত মই সেই ঘৰৰ আচবাব নাও দিছ পোৰ্চন ইজ ভেৰি ভেৰি ইম্পৰ্টেণ্ট শ্ৰাদ্ধৰ পিছত মই ঘৰৰ আচবাব তথা সা সামগ্ৰী ঠিক কৰি থাকোঁতে এটা বাকচৰ ভিতৰত 3/3/2004 তাৰিখে সম্পাদন কৰা প্ৰদৰ্শক এক উইল পত্ৰখন পাওঁ specific statement given by the petitioner where she found the will. Now the next sentence is also very important. Lordship may kindly take note of this sentence.
Okay.
উক্ত উইলখনত থকা সাক্ষীৰ নামসমূহ মোৰ চিনাকি হোৱাত মই তেওঁলোকক উইলখনৰ বিষয়ে সোধাত উক্ত উইলখন মোৰ স্বামীয়ে সম্পাদন কৰা বুলি কোৱাত আৰু মোৰ সাক্ষীৰ চহীসমূহ মোৰ চিনাকি হোৱাত মই সন্মানীয় আদালতত উইল পত্ৰখন লেটাৰ অফ এডমিনিষ্ট্ৰেশ্যন পাবৰ বাবে গোচৰ তৰিছোঁ Now for a moment I am taking your lordship to the cross-examination part. I'm just stopping here and taking your lordship to the cross-examination part of PW.
You first read the entire evidence.
Yes.
A few
All right.
paragraphs are there only.
Yeah. প্ৰদৰ্শক 2 উক্ত উইল আৰু প্ৰদৰ্শক 1 পৰা 1/6 লৈ মোৰ মৃত স্বামী গোলাপ দাসৰ চহী প্ৰদৰ্শক 1/7 সাক্ষী ৰমণী ডেকাৰ চহী 1/8 সাক্ষী খৰ্গেশ্বৰ কলিতাৰ চহী 1/9 বাপুকন তালুকদাৰৰ চহী 1/10 সাক্ষী কৃষ্ণা ৰায়ৰ চহী প্ৰদৰ্শক 2 সন্মানীয় আদালতত লেটাৰ অফ এডমিনিষ্ট্ৰেশ্যন পাবৰ বাবে কৰা মোৰ মূল দৰখাস্ত প্ৰদৰ্শক 2/1 পৰা 2/7 লৈ মোৰ চহী প্ৰদৰ্শক 2/8 পৰা 2/9 লৈ সাক্ষী ৰমণী ডেকাৰ চহী মূল দৰখাস্ত এনেক্সাৰ A এনেক্সাৰ B উল্লেখ কৰা স্থাবৰ আৰু অস্থাবৰ সম্পত্তিখিনিৰ ওপৰত উইল কৰি যোৱা মতে লেটাৰ অফ এডমিনিষ্ট্ৰেশ্যন পাবৰ বাবে মই এই গোচৰটো তৰিছোঁ এই কথা মোৰ জ্ঞান আৰু বিশ্বাস মতে সত্য মই LIC পলিচি নাম্বাৰ সোয়েন্সৰ টকা পাবৰ কাৰণে LIC লৈ আবেদন কৰাত LICয়ে তেখেতসকলৰ 7/2/2007 তাৰিখৰ চিঠিযোগে উক্ত পলিচি তেওঁলোকক দাখিল দিবলৈ কোৱাত মই সেই পলিচি LICতে জমা দিওঁ প্ৰদৰ্শক 3 উক্ত চিঠি পিছত LICয়ে 8/6/2007 তাৰিখৰ চিঠিৰ যোগে মোৰ পৰা সাকসেশন সার্টিফিকেট বিচাৰাত আন সম্পত্তিৰ লগতে এই পলিচিৰ টকা পাবলৈ এই গোচৰ তৰিছোঁ প্ৰদৰ্শক 4 উক্ত চিঠি এই কথা মোৰ জ্ঞান বিশ্বাস মতে সত্য এই শপত পত্ৰ মই তৰা গোচৰ সাক্ষী ৰূপে ব্যৱহাৰ হ'ব এই কথা মোৰ জ্ঞান আৰু বিশ্বাস মতে সত্য এই শপত পত্ৰ সোয়েন্স My lord, may kindly come to
Cross-examination.
cross-examination part.
Yes.
মই এতিয়া জয়মতী পথাৰৰ ওচৰত থাকো মৃতক গোলাপ দাস ওৰিয়েণ্টেল ইঞ্চুৰেঞ্চ কোম্পানীৰ তেজপুৰ ব্ৰাঞ্চত চাকৰি কৰিছিল তেখেতৰ বিশ্বনাথ চাৰিআলিৰ পানীভাৰ গাঁৱত মাটি বাৰী আছে তাতে তেখেতৰ পৰিয়ালবৰ্গ থাকে গোলাপ দাস মোৰ স্বামী বুলি এফিডেভিটত লিখিছো প্ৰপত্ৰ 1 উইলখনতো গোলাপ দাস মোৰ স্বামী বুলি উল্লেখ আছে মই বিয়া কৰোৱাৰ আগতে মৃতকে 1 নং শপত পত্ৰৰ ৰীনা দাসক বিয়া কৰাইছিল আৰু তেওঁৰ ফালৰ পৰা দুজন ল'ৰা উত্তম দাস আৰু আদিত্য দাস আৰু ৰিম্পী দাস আছে বুলি দৰখাস্তত লিখিছো মই এই গোচৰ কৰাৰ আগতে ৰীনা দাসে আদালতত মৃতকৰ ডেপ্ট এণ্ড চিকিউৰিটিজৰ বাবে ছাকচেছন চাৰ্টিফিকেট পাবৰ বাবে মিছ চ' এণ্ড চ' কৰিছিল। সেই গোচৰত ৰীনা দাসে মোক মৃতকৰ ৱাৰিছ বুলি উল্লেখ কৰা নাছিল আৰু মোক নটিচো দিয়া নাছিল। পিছত মই মৃতকৰ দ্বিতীয় পত্নী আৰু উইল গৃহীতা হিচাপে পদ কৰিবলৈ দৰখাস্ত কৰিছিলোঁ আৰু সেই পিটিশ্যন এলাউ হৈছিল। ৰীনা দাস মৃতকৰ পত্নী আছিল, মই জনা নাছিলোঁ। হিন্দু ধৰ্মমতে প্ৰথম পত্নী জীয়াই থাকিলে স্বামীয়ে দ্বিতীয় বিবাহ কৰিব নোৱাৰে বুলি মই ভাবোঁ। মৃতকে মোক 2002 চনৰ 4 ফেব্ৰুৱাৰী বিশ্বনাথ চাৰিআলিৰ পৰা বিয়া কৰাই আনে। মৃতক পানী ভঁৰাল গাঁৱত ৰীনা দাস আৰু ল'ৰা ছোৱালীৰ লগত থকা কথা মই জনা নাছিলোঁ, কিন্তু তেখেতৰ ঘৰ পানী ভঁৰাল গাঁৱত বুলি জানিছিলোঁ। মোৰ দৰখাস্তত মই দাবী কৰা সম্পত্তিৰ বিৱৰণ আছে। মৃতকৰ গ্ৰেচুইটি প্ৰভিডেণ্ট ফাণ্ড ৰীনা দাসক নমিনী কৰা আছে। LICত এটা মোৰ নামত নমিনী আছে। এটা so and so it's not legible in my এটা লেপছ হৈছে গ্ৰুপ ইঞ্চুৰেঞ্চ নমিনী ৰীনা দাস আছে। ফেমিলি পেঞ্চন ৰীনা দাসে পাব লাগে বুলি উল্লেখ কৰিছে। ইউনাইটেড বেংকত মৃতকৰ এটা লোন একাউণ্ট আছে। মোৰ দৰখাস্ত আৰু এফিডেভিটত মৃতক তেজপুৰৰ মাজগাঁৱত অস্থায়ীভাৱে আছিল উল্লেখ আছে। 22/7/6 তাৰিখে দৰং কলেজৰ ওচৰৰ ঘৰতে স্বামী ঢুকাই। গোলাপ দাস ঢুকুৱাত মই ৰীনা দাসক খবৰ দিওঁ। গোলাপৰ ভাই আৰু ৰীনাৰ ভাই আহিছিল। ৰীনা দাসৰ ল'ৰা মৃতকৰ মুখাগ্নি কৰে। ময়ো শ্মশানত যাওঁ। দহা কাম আমি বেলেগে কৰোঁ। সত্য নহয় যে যিহেতুকে মই গোলাপ দাসৰ পত্নী নাছিলোঁ, গতিকে তেখেতৰ দহা কৰ্ম কৰাত মোৰ অধিকাৰ নাই। শ্ৰাদ্ধ মই ইয়াতে ভতিজা পাতিছোঁ। ৰীনা দাসে বিশ্বনাথত পাতিছে। সত্য নহয় যে মই শ্ৰাদ্ধ কৰাৰ কোনো অধিকাৰ নাছিল। ফাৰ্দাৰ ক্ৰছ এক্সামিনেশ্যন। ৰীনা দাস মোৰ স্বামীৰ পত্নী বুলি জানিব পাৰি গোচৰৰ দৰখাস্ত দিছিলোঁ। গোলাপ দাসৰ মৃত্যুৰ এবছৰ আগৰ পৰা পানী ভঁৰাল গাঁৱলৈ যোৱা নাছিল। মাজগাঁৱৰ ৰত্নপুৰত 8/2/2002 তাৰিখৰ পৰা 22/3/2006 তাৰিখলৈ একেলগে আছিলোঁ। মোৰ কোনো সন্তান নাই। প্ৰপত্ৰ 1ত গোলাপ দাসে মোক তেখেতৰ পত্নী বুলি লিখিছে। ৰীনা দাসে এটা ছাকচেছন কেছ কৰিছে আৰু কেছৰ তাৰিখ আজি আছে। এই গোচৰতে ৰীনা দাসে মোক পদভুক্ত কৰা নাছিল। পিছত মই দ্বিতীয় পত্নী বুলি দৰখাস্ত কৰি পদ হৈছোঁ। উক্ত গোচৰ প্ৰতিদ্বন্দ্বিতা কৰিছোঁ। গোলাপ দাসৰ মৃত্যুৰ এবছৰ আগতে মটৰচাইকেল এক্সিডেণ্ট হৈছিল। নাও দিছ পাৰ্ট ইজ অলছ' ইম্পৰ্টেণ্ট। গোলাপ দাসৰ মৰাৰ এবছৰ আগতে মটৰচাইকেল এক্সিডেণ্ট হৈছিল। ভৰিত জখম হৈছিল, ব্ৰেইনতো দুখ পাইছিল। It is admitted that he suffered brain injury. পিছত তেওঁৰ কেঞ্চাৰ ৰোগ ধৰা পৰে। সেই সময়ত তেওঁ মোৰ লগত তেজপুৰত আছিল। এক্সিডেণ্ট হোৱা, কেঞ্চাৰ হোৱা আদি কথা মই ৰীনা দাসহঁতক বিশ্বনাথ চাৰিআলিৰ ঘৰত জনাইছিলোঁ। ৰীনা দাসৰ ল'ৰা আৰু ছোৱালীয়ে চাব আহিছিল। গোলাপ দাসক মৃধা হস্পিটেলত ভৰ্তি কৰাইছিলোঁ। সত্য নহয় যে 3/3/2004 তাৰিখে গোলাপ দাস সুস্থ হৈ আহি প্ৰপত্ৰ 1 উইল কৰিছিল। সত্য নহয় যে গোলাপ দাসৰ কেঞ্চাৰ হোৱা বুলি জানিব পাৰি তেখেত বেছি দিন জীয়াই নাথাকিব বুলি ভাবি তেখেতক প্ৰৰোচিত কৰি প্ৰপত্ৰ 1 উইলখন কৰাই লৈছো। অৰিজিনেল ইঞ্চুৰেঞ্চৰ এটা পলিচি মান্থলি পেঞ্চন প্ৰভিডেণ্ট ফাণ্ড গ্ৰেচুইটি আদি সকলো ছাৰ্ভিচ বেনিফিট এই উইলৰ দ্বাৰা পাইছো। উইলখন পাই মই খুলি চাইছো, সেইখন খুলি চাইছো। This sentence is also important. উইলখন পাই মই খুলি চাইছো। উইলখনত লিখা আছে যে ৰীনা দাস তেওঁৰ প্ৰথমা পত্নী আৰু তেওঁৰ ফালৰ 2টা পুত্ৰ সন্তান আৰু এটা কন্যা সন্তানৰ তেওঁ মাতৃ। এইটোত লিখা আছে যে প্ৰায় 2 বছৰ ধৰি গোলাপ দাসক তেওঁলোকে বামগাঁৱৰ ঘৰলৈ যাবলৈ দিয়া নাই আৰু নাযাবলৈ ভাবুকি দিয়ে। মই গোলাপ দাসৰ সেৱা শুশ্ৰূষা কৰি আছো বুলি উইলত লিখা আছে। যিহেতু গোলাপ দাসে শেষ বয়সত ৰীনা দাস আৰু ল'ৰা ছোৱালীৰ পৰা শুশ্ৰূষা নাপালে তেওঁ মোক আঁকোৱালি ল'লে বুলি উইলত লিখা আছে। 5খন ইঞ্চুৰেঞ্চ পলিচি মোক দিয়া বুলি উইলত লিখা আছে যদি মই নাজানো। বামগাঁৱত বামগাঁৱত ঘৰ মাটিৰ ভাগ মোক দিয়া নাই। নাগশংকৰৰ গোলাপ দাসৰ 2 বিঘা 2 কঠা মাটি আছিল আৰু সেই মাটি মই পাম বুলি উইলত উল্লেখ আছে বুলি উইলত লিখা আছে। এই উইল লিখোতে তেজপুৰৰ তৰণী সন্থাত তৰণীৰ দ্বাৰা লিখা বুলি উইলত লিখা আছে। Now, these are very important sentences. মই লগত অহা নাই। কোন সাক্ষীয়ে উইলত সহি কৰিছে মই নাজানো। উইলখনত সাক্ষী ৰমণী ডেকা, কৃষ্ণা ৰয়, খৰ্গেশ্বৰ কলিতাক চিনি নাপাওঁ। মই যিহেতু গোলাপ দাসৰ লগত অহা নাছিলো গতিকে এই সাক্ষীগণে উইল কৰাৰ সময়ত উপস্থিত আছিল নে নাই মই নাজানো। কোন মহৰীয়ে উইল লিখিছে মই নাজানো। বাদীগণে মোৰ সন্মুখত উইলত সহি কৰা নাই। Totally different version from her evidence on affidavit where she stated that after getting the will, after the death of her husband, she inquired about the same with the attesting witnesses because she knew them. Now she is stating, I do not know who is the attesting witness, who is the scribe, whose name is there in the will. I do not know. So how the learned trial court can entertain or can take into consideration of these statements of the petitioner for consideration of her prayer? She has failed to prove her own case. So because of this reason, learned court below was of the opinion that these witnesses are not trustworthy. It did not come from our side that there was some coercion, there was some fraud. It's not from our side. It's from the side of the court itself that they have failed to prove their own statement. They have failed to prove the will, execution of the will itself. There are different stories from the side of the petitioner, from the side of the attesting witness. The next part, my lord. গোলাপ দাসে যদি উইলৰ কাগজখন লিখি ঘৰলৈ নিছিল তেন্তে মই নাজানো। বাদীগণে কেতিয়া সহি কৰিছিল বা গোলাপ দাসৰ উপস্থিতিত সহি হৈছিল নে নাই মই নাজানো। প্ৰপত্ৰ so ৰমণী ডেকা, খৰ্গেশ্বৰ কলিতা, কৃষ্ণা ৰয় সহি হয় নে নহয় মই নাজানো। প্ৰপত্ৰ সহিটো দলিল লিখক বাপুকণ কলিতাৰ চহী হয়নে নহয় মই নাজানো সত্য নহয় যে গোলাপ দাসক পানী ভঁৰাল গাঁৱলৈ যাব নিদিয়াৰ সুযোগ লৈ মই তেওঁৰ লগত মাজগাঁৱত অবৈধভাৱে বসবাস কৰি আছিলো সত্য নহয় যে ৰীনা দাস প্ৰথমা পত্নী আৰু তেওঁৰ 3টা সন্তান থকা বুলি মই আগতেই জানিছিলো মই ৰীনা দাসক দেখা নাই ৰীনা দাসৰ বৰ্তমান বয়স যদি 55 years মই নাজানো সত্য নহয় যে অবৈধ সম্পৰ্ক আৰু আনডিউ এডভান্টেজ লৈ one of the attesting witness other remained absent what he stated
Only one witness examined.
only one witness examined
Attesting witness.
One attesting witness.
and one
the scribe.
scribe was there so what he stated in his evidence lordship may kindly have a look once again মৃত গোলাপ দাস আৰু মোৰ ঘৰ ওচৰা ওচৰি আৰু তেখেতক মই ভালদৰে চিনি পাইছিলো মহাভৈৰৱ দৈনিক বজাৰত মোৰ এখন শাক-পাচলিৰ দোকান আছে আৰু মৃত গোলাপ দাস জীৱিত অৱস্থাত প্ৰায়ে মোৰ দোকানলৈ বজাৰ সামৰ কৰিবলৈ আহিছিল মই মৃত গোলাপ দাসৰ পত্নী শ্ৰীমতী গীতাঞ্জলি দাসকো চিনি পাওঁ categorical statement that he knows her Gitanjali Das he knows her গত ইংৰাজী 2-3-2004 তাৰিখে গোলাপ দাস মোৰ দোকানলৈ সন্ধিয়া সময়ত আহিছিল আৰু কৈছিল যে তেওঁৰ দুইগৰাকী পৰিবাৰৰ মাজত তেওঁৰ সম্পত্তি সম্পৰ্কে যাতে কোনো বিবাদ হ'ব নোৱাৰে সেই উদ্দেশ্যে তেওঁ এখন উইল কৰিব বিচাৰিছে আৰু সেই উইলৰ এজন সাক্ষী হিচাপে মোক সহি কৰিবলৈ অনুৰোধ কৰিছিল আৰু মোক পিছদিনা অৰ্থাৎ 3-3-2004 তাৰিখে দিনৰ প্ৰায় 11 বজাত তেজপুৰ আদালতৰ মহৰীখানাত আহিবলৈ অনুৰোধ জনাইছিল তেখেতে মোক কৈছিল যে তেখেতে মোৰ দোকানৰ ওচৰতে শ্ৰী ৰমণী ডেকাকো এই বিষয়ে অনুৰোধ কৰিছে মৃত গোলাপ দাসৰ আৰু এগৰাকী পৰিবাৰ আছে বুলি মই আগে জানা নাছিলো আৰু তেখেতক এই বিষয়ে সোধাত তেখেতে ক'লে যে তেওঁৰ প্ৰথমা পৰিবাৰে তেওঁক অৱহেলা কৰাত আৰু তেওঁৰ লগত থাকিবলৈ অস্বীকাৰ কৰাত তেওঁ শ্ৰীমতী গীতাঞ্জলি দাসক তেওঁৰ পত্নী ৰূপে গ্ৰহণ কৰিছে মৃত গোলাপ দাসৰ আগদিনাৰ অনুৰোধ মৰ্মে আৰু ৰমণী ডেকা 3-3-2004 তাৰিখে প্ৰায় 11 বজাত ৰমণী ডেকাৰ স্কুটাৰত উঠি তেজপুৰৰ আদালতৰ মহৰীখানালৈ যাওঁ আৰু তাত মৃত গোলাপ দাসৰ মহৰী শ্ৰী বাপুকণ তালুকদাৰক মই ওচৰত দেখা পাওঁ উক্ত বাপুকণ তালুকদাৰক মই আগৰ পৰা চিনি পাওঁ আমি
One page is missing here.
Hello?
Page number 3. Yes, okay, it is.
page number 3
yes.
and 4
Yes.
আমি সেই ঠাই গৈ পোৱাৰ পিছত উক্ত শ্ৰী বাপুকণ তালুকদাৰে মৃত গোলাপ দাসে কোৱা মতে প্ৰদৰ্শক এক উইলখন লিখে আৰু লিখি পঢ়ি সকলোকে আমালোক ন শব্দ আমি আটায়ে কেইজনক পঢ়ি শুনাই আৰু প্ৰদৰ্শক এখন পঢ়ি শুনোৱাৰ পিছত তাত লিখা কথা ঠিক আছে বুলি কৈ মৃত গোলাপ দাসে প্ৰদৰ্শক এক আৰু মোৰ আৰু ৰমণী ডেকাৰ সন্মুখতে চহী কৰে আৰু তেওঁ চহী কৰাৰ পিছত মই আৰু ৰমণী ডেকাই উইলখন প্ৰদৰ্শক একত চহী কৰো প্ৰদৰ্শক একৰ পৰা 1-6 লৈ আমাৰ আগত কৰা গোলাপ দাসৰ চহী আৰু প্ৰদৰ্শক 1-7 ৰমণী ডেকাৰ চহী 1-8 মোৰ চহী 1-9 লিখক বাপুকণ দাসৰ চহী ইয়াৰ পিছত লিখক বাপুকণ দাসে উক্ত প্ৰদৰ্শক এক উইলখন আমাৰ সন্মুখতে মৃত গোলাপ দাসৰ হাতত দিয়ে আৰু মই আৰু ৰমণী ডেকা তেওঁৰ স্কুটাৰত উঠি আমাৰ দোকানলৈ যাওঁ প্ৰকাশ থাকে যে উক্ত প্ৰদৰ্শক এক উইল লিখাৰ সময়ত আমাৰ ওচৰত এগৰাকী মাইকী মানুহ আছিল কিন্তু আমি তেওঁক চিনি নাপাওঁ এই শপতপত্ৰ বাদিনীয়ে কৰা গোচৰৰ সাক্ষী ৰূপে ব্যৱহাৰ হ'ব now the cross examination part of PW3 what I am trying to show before your lordship, the second paragraph of the cross-examination part. I'm only reading the second paragraph. Romani Dekar Dukan Mur Logote. Will Korute Gulab Das, Gitanjali, lordship may kindly. Gitanjali was there. And what did the Gitanjali say? Gitanjali found the will in a box after the death of her husband, and she did not know anything before that. That will was created in her favor. So these all statements has created doubt. Because of that, probate is not granted. Now, how can these statements can be believed? And on all these statements, probate can be granted in respect of a will. I have nothing to say regarding the judgment placed by my learned friend. Judgments are there. Judgment says. Judgment says some other things. When the will is there, then attesting witness, one attesting witness's evidence is enough to prove a will. Look, these things are there. But what I am trying to indicate, my lord, plaintiff has to prove his own case, which they have failed. Because of that, the judgments which the learned court below in both the cases have passed, these are all correct judgments, my lord. It doesn't need any interference from this honorable court. So I have nothing to say regarding the judgments placed, and I'm not against the law. I'm only saying these witnesses are not trustworthy. They have failed to prove their case, because of which their case failed. This is my humble submission.
Your part is over. Only one part. Oh, only 1 point.
1 point, my lord, because they have failed to prove their case. They have projected some stories which are contradictory. One says something, the other says something.
Yes.
My lord, in my humble submission, no interference is required in both the judgments. Both judgments are based on the facts and evidences laid before the learned courts below.
So the second petition is for what purpose?
Second was, my lord, this petition was filed by me for granting succession in my favor. And both these cases ran concurrently because finding of one case would have affected the other one. So first this will matter was decided, probate matter was decided, and after concluding that matter, the impact on the other matter.
If I could succeed in this case, lordship, then other will fail. So it will be.
These cases impact will directly hit the impact of the other case.
So
Because
this
I am the first one-
Bapukon Talukdar was the scribe.
Right.
And what is the evidence of Romani Dekar?
Romani Dekar, his evidence was expunged because he did not put forward his cross-examination.
Acha.
Two other witnesses were there, evidence on affidavits were filed, but since they did not put
Three of
forward-
them signed, but only one appeared for cross-examination. He is Khargeshwar Palla, which my friend has read out. So one is enough, lordship,
Acha.
as per section 68, lordship.
Acha. Then what about this Bapukon Talukdar? Then
Bapukan Talukdar scribe has adduced his evidence, Lordship.
No, whether he deposed anything about presence of,
He appeared for cross, Lordship.
no, that's all right. Whether he deposed about presence of Rina,
He said,
sorry, Gitanjali Das at the time of,
he said in his cross-examination, Gitanjali ahisil ne nai moi nazanu.
acha.
This is his second paragraph of his cross-examination.
Hmm.
And another aspect he has stated in paragraph 3 of his cross-examination, Propotro ekor prothom pristhar aru tritiyo pristhar tolot Gulab Dasor sohi nai.
So in the second case, Gitanjali Das is the
Since she was the
appellant.
first wife, she is the first wife, succession is granted in her favor.
No, Gitanjali is the second wife.
She got impleaded and contested.
Yes.
Initially, Rina Das applied.
She is appellant in this petition.
Both the cases were decided against
Me.
Gitanjali Das.
In view of this, I failed in the first case, Lordship.
Yes.
So the second case was allowed. Obviously, that if I could not succeed in the first one, Lordship, it will be just the consequential part, Lordship.
Okay. Heard Mr. B. Chakraborty, learned counsel for the appellant, and also heard Mr. Your good name, please?
M. Sodri.
M. Sodri, learned counsel for the respondent. Argument concluded, order reserved.
I'm okay.
Obliged.
At number 9, timing item.
Lordship, in this case, actually earlier I have gone through the orders and talked to Leonard friend also. Earlier I appeared along with my senior. Lordship, today my name was not shown. Lordship, allow me some time, I will reconstruct my file and I will do the case.
Pardon?
I'll do the case, Lordship, allow me some time.
Acha.
Because my name was also not shown for this. So, and on the information of my Leonard friend.
Okay. Heard Mr. S.C. Kayal, learned counsel for the appellant, and Mr. Goswami, learned counsel for the respondent. Mr. Kayal, learned counsel for the appellant, submits that his name is not reflected in the cause list. And therefore, he submits that the case may be posted on a different date, directing the registry to reflect his name in the cause list. And on that day, he will be able to argue the matter. Here is accordingly allowed, registers and leaves the matter after vacation.
After vacation, my date may fix mellow. That's old case mellow. Any date mellow.
On 5th November.
Obliged.
Timing item 7.
May I please, Your Lordship?
Lordship, in this case, I have filed an IA for modification of the order that has been passed by this honorable court, and that is at this is IA number 1392/2024. The order passed by this honorable court is at Annexure 2, page 13. Lordship, what we have prayed, what happened in this case, the 50%, the trial court has directed the petitioner to pay 50% to his wife of the retirement benefit to his wife. Then against that order, he has approached this honorable court, and this honorable court has stayed the order of the trial court. And in the meantime, the petitioner, who was an employee of the ONGC, he was due to retire and he has already retired. So at that point of time, we have filed modification of the order passed by this honorable court to the extent that the 50% may be retained with ONGC and 50% may be released. Because the 50% will serve my purpose and my interest will be served, because later, if some alimony is granted, that is why I have filed. And at that point of time, but the entire pensionary benefit was stopped. Now we do not have any objection if the 50% is released.
Lordship, that is there, your lordship. If 50% release in my behalf, that is not disputed, your lordship.
And my
So say we can pay the maintenance amount, your lordship, because maintenance amount is not releasing for few months, no? Because that
entire pension was stopped.
yeah, entire pension is
Where is the order?
Lordship, probably the initial order of this honorable court is at Annexure 2, and there is an order
in the IA.
Yes, Lordship.
IA number 1392.
Yes, Lordship.
Page number?
Page number, it is in the page number 14 is the operative portion. Till the returnable date, the order dated 30/10/2023 passed by the learned additional district judge Shivsagar in TS within packet M number 24 of 2018 shall remain stayed. And this was subsequently modified by this honorable court by the order dated 29.
That order was that modified order, lordship. 29/5.
Yes, Lordship. Probably.
Yes. What is the order? Entire pensionary
29/5.
Yeah, entire pensionary benefit were in the custody of the ONGCL, lordship. So now,
What is your prayer?
My prayer is that 50% may be released, because my specific prayer is only to retain 50%, because so that if the alimony is granted subsequently, or that if I succeed in this petition, at least my interest will be protected, because there is no regular pension in ONGC and it is given in one time only. So I have prayed for retention of 50% of the benefit with the ONGC, not with me.
yes, with the ONGC custody, your lordship.
50% of the pensionary benefit. That was my prayer. And 50% may be released.
50% may be released in my favor, your lordship, so that I can pay the maintenance amount, and that amount, maintenance amount, is automatically cut from the account, your lordship. Or there is in system, auto cut is there, auto transfer, your lordship. So it will automatically go to her.
No, there was in the order dated 12/2/2024, there was direction for payment of monthly maintenance
Yes,
at the rate
Lordship.
of rupees 30,000.
Lordship, that monthly maintenance that was given earlier, that was continuing.
Continuing,
And
lordship.
thereafter, that the trial court has granted 50% of the, directed the petitioner to pay the 50% of his monthly, ONGC was directed to pay the 50% of his retirement benefit to me, because he was due to retire.
Trial court.
Yes, Lordship, that order is under challenge here. Trial court order I have annexed with this miss case, it is at Annexure 1, page 9.
Now you are in this IA or the.
It is in the IA also, I have annexed the order.
I
No,
can
no,
be
that's all
disposed
right.
of, your lordship, at this stage. That can be disposed of, no?
Lordship.
IA.
Yeah, lordship.
Lordship,
But
may
there's
kindly
a
turn
main
to page
petition
number.
and there's a CRPIO.
Lordship, in this CRPIO, we have prayed for that at least 50%, because the trial court has given the 50% to me. That order has been stayed by this honorable court. Thereafter, I have filed a IA as because the petitioner was retiring in between. So I was compelled to file a IA so that to retain the 50%, because if it goes to his hand, he may not give me. So that is why till disposal of this CRP, I have given, we have filed this 50% may be retained with the ONGC. That was the prayer. At that point of time, the prayer was made from the petitioner side that entire pension may be stopped. That was stopped, and thereafter by the order dated 29/5. So now we are only asking for 50% to be stayed.
You are for the wife.
Yes, Lordship. Trial court order is at page 11 of the IA that I have filed, 1392.
So this title suit was for what purpose?
It is for divorce.
Divorce, Your Lordship.
He has
That
filed one
is
title suit.
pending, Your Lordship, before additional district judge, Your Lordship.
In that, one petition was filed as he was retiring. So 50% may be given to the wife. So that direction was given.
Petition filed on 5/7/23. for
Whether
retirement
that title suit is
Still
disposed
pending.
of?
Pending,
Still
Lordship.
pending.
Pending because divorce petition is pending.
Hmm.
In that divorce petition, the wife has filed a petition
No,
on the
now you
basis
tell
of
me whether we can dispose of this IA also.
Yes,
No. This CRP also.
CRP. Lordship.
What is the pair in the CRP?
CRP, they have challenged this order of 50%.
We have challenged that order, Your Lordship.
That order of the trial court whereby the 50% was to be given.
That
to the
impugn order, Lordship, that is
Hmm.
38/10 to 2023. That order we have
No,
challenged.
now the person has retired.
Yes.
So his retirement benefit is to be released.
Hmm.
As per the direction of this honorable court dated 29/5/2024,
Hmm.
entire pension has been stopped now. Retirement benefit has been stopped.
Hmm.
And out of that, now we are saying that 50% may be released. We do not have any objection.
Hmm.
And 50% may be retained to ONGC till disposal of this CRP.
Hmm.
In that impugn order, Your Lordships,
Hmm.
that trial court directed to give 50% of the amount to wife, pensionary benefit, Lordship. Lordship. But without invoking any provision of law, Lordship, only a petition on the basis of a petition dated 5/7/23, page number 34, Your Lordship. Annexure 5, Your Lordship. By that petition, she has claimed for 50%, 70% of the pensionary benefit of the petitioner, Lordship. But the trial court allowed her 50%. But without invoking any provision of law, which trial court cannot do, Lordship. Trial court has passed that impugn order, Your Lordship. We have come before this honorable court against that impugn order, Your Lordship.
Now, what purpose will be served if we keep that matter pending?
Lordship?
No, the CRP?
Lordship, then, because if this CRP is disposed of, and if the order dated 30/10/2023, thereby 50% has already been given to the wife. So that will come into force. Now, till what we have prayed in this IA, that till disposal of this CRP.
No, if we finally hear and dispose of the IA, no, this CRP, then
Lordship, that can be done.
That can
If
be
a
done,
date
Lordship. That can
date
be
is
done.
fixed in the next week, that can be done.
so instead of keeping the matter pending, we can finally
Lordship,
hear
that
and
can be
dispose
done.
of the same.
Yes, Lordship.
Because the person concerned has already retired.
Yes, Lordship. But on next Tuesday, Lordship, this can be.
Why not today? At 2 PM you come prepared?
Lordship, actually, today at 2 PM, I have to take my mother to hospital.
Lordship, I have also matter in court number 10, Lordship, hearing at 2, Lordship.
Acha.
That is the trouble. Otherwise,
Then on next Tuesday, COVID possible?
Any date as per your Lordship's convenience.
any date, Lordship.
Goodbye, goodbye. Can we fix it on Wednesday? Next Wednesday.
Wednesday, 18. Lordship,
Yes.
Lordship, obliged.
No, instead of keeping the matter pending, we
Lordship,
can
that will-
finally hear and dispose of the same.
That can be done. Lordship.
Today we will keep it as further.
Yes, Lordship, that can.
Heard Mr. Dasgupta, learned counsel for the petitioner, and Mr. S.N. Tamumi, learned counsel for the respondent. Heard in part, lays the matter on next Wednesday for further hearing.
Obliged, Lordship. Much okay.
May I please, Your Lordship. My lord, in respect of the next item, item number 16 and 17.
Yes.
The previous order passed, it was, these two matters were heard by Justice Kalita. And the CB one at that point on time was heard at length. And thereafter, the Honorable Court decided that I should file a written submission on both these matters. I have prepared the submission, a slight bit of legal points are required to be covered. So I require some time, subject to your Lordship's convenience. If if your Lordship desires to hear the matter, then from afresh, then maybe taken up next week, or else it can be posted before the bench hearing the matter.
No, if that bench has already heard the matter,
Yes, it appears from the order, although not part heard, but from the order it is reflected.
Hmm?
It is 16 to 17.
Yes, Decca?
It can go to the same bench, my lord.
Hmm.
Will your lordship kindly fix a date, my lord, because next.
No, it will be difficult for this court to fix the date because we do not know the burden of that court.
Correct.
Heard Mr. Borua, learned counsel for the appellant, and Mr. Decca, learned counsel for the respondent. Mr. Borua submits that this matter was earlier heard by another coordinate bench of this court. And as such, it ought to have been listed before the said bench. Accordingly, it is provided that Justice shall list the matter before the appropriate bench.
Obliged.
Same order in 17 also.
17 also say.
Timing item number 11.
Wait, please, Your Lordship. This second appeal has been preferred by the defendants, Lordship. Suit was filed by the respondent for specific performance of contract on the basis of an unregistered deed. The very beginning, suit was decided ex parte. Thereafter, we filed Order 9 Rule 13 petition that was allowed. And then, Lordship, after appearance of the appellants by filing written statement and adducing evidence, suit was dismissed, Lordship. Then they preferred title appeals, and First Appellate Court remanded the suit to the trial court to decide afresh by Lordship sending the Exhibit 1 for FSL report, Lordship. And thereafter, Title Appellate Court, Lordship decreed the suit, and against that, we are preferring this regular second appeal. Plain to your Lordship will find in page 6 type copy, and relevant prayer portion I will read, Lordship, that is page 9. Lordship.
First, let us say the substantial question of law.
It was admitted on 15/10/2015. Whether the learned court below failed to appreciate the true purported section 101 with 102 of the Evidence Act while deciding the issue number 5 in favor of the plaintiff by decreeing the suit. In this case, what happened, Lordship, after remand, The exhibit one was sent for forensic report, Lordship. The forensic report
No,
is,
the Lorded court below means which court?
Lordship.
In the
First
substantial
appellate
which,
court, first appellate court.
first
Lordship.
appellate court.
Yes, Lordship. Trial court dismissed the suit, so Lordship, the judgment was in favor of the appellants, Lordship.
Who is for the respondent?
I am a bit low. I am led by the D. Mugundar.
May I read the title suit judgment, Lordship?
Yes. Video.
Page 29, Lordship, point of dispute in the trial court judgment. From the pleadings of the parties, it is learned that the plaintiff number one and defendant number one was entered into an agreement to
Page
sell.
number, page number?
29, Lordship.
Yes.
From the pleadings of the parties, paragraph 7, Lordship. It is learned that the plaintiff number one and defendant number one was entered into an agreement to sell of the suit land in the consideration amount of rupees 1,50,000, wherein the plaintiff paid rupees 1,40,000 to the defendant number one. The defendant number one assured that he will execute the sale deed in favor of the plaintiff within 1 year, but the defendant number one did not do so. The defendant, on the other hand, submitted that he never execute any sale agreement in favor of the plaintiff number one and completely denied the allegation of the plaintiff along with his signatures made therein in the exhibit one. This is the main controversy and bone of contention between the parties. During my trial, my learned predecessor in the chair framed issues after perusing the pleadings and hearing of the parties. The issues are: if there is any cause of action for the suit, whether the suit is maintainable in its present form, whether the suit is barred by law of limitation, whether the suit is barred by the law of contract, whether the plaintiff is entitled to get a decree as paid for, to what reliefs the plaintiffs are entitled. I have perused the entire pleadings of the parties carefully and the evidences and the documents submitted by them during the trial. I have also heard arguments advanced by the parties at length. Upon consideration of such perusal and hearing made by the parties, I have found that the issue number 5 and issue number 6 framed in respect of whether the plaintiffs are entitled to get a decree as prayed for, as well as reliefs prayed for, is the prime issues between the parties. As such, the issue number 5 and issue number 6 is taken for discussion at the first instance in the given suit. As it has already been discussed that the issue number 5 and issue number 6 is the prime issue, as such, we shall take the discussion on the basis of the pleadings of the parties, their evidence vis-a-vis the documents submitted by them. While the pleadings of the parties were scrutinized and the issues were framed, it was seen and found that the suit was for the enforcement of specific performance in view of Exhibit 1. Therefore, the crux point for discussion of the suit will be in the execution of Exhibit 1. Hence, let us now discuss the evidences of the parties to determine if the Exhibit 1 was duly executed between the parties or not. The plaintiff side in favor of their case adduce the evidences of one witness and the defendant side adduce the evidence of one witness in their favor. The plaintiff number 1, now deceased, Abdul Hadi, was examined as DW1, who in his deposition on affidavit adduced that he and the defendant number 1, now deceased, Desmond Anthony, was entered into an agreement to sale of the suit property on 1/2/1995 in consideration of an amount of rupees 1,50,000, and the defendant received an amount of rupees 1,40,000 in advance, specifying the condition in Exhibit 1 that the defendant number 1 will execute and register the sale deed in favor of the plaintiff number 1 within 1 year. The plaintiff submitted the deed of agreement, which is marked as Exhibit 1. It is found that
the exhibit one is an unregistered deed and the defendant number one in his evidence, being the DW1, denied the execution of the said deed, as it is the established principle of law that the burden of a fact is entirely resting upon the party seeking the relief, and as such, in the case in hand, it is the burden upon the plaintiff to show and to prove that the exhibit one was executed by the parties. Again, here in the instant case, the defendant denied the execution of exhibit one. And since the exhibit one was an unregistered document, the plaintiff ought to have to produce the independent witness to satisfy the court that the exhibit one was executed between the parties and the defendant number one had put his signature therein in the presence of those independent witnesses, but the plaintiff did not produce and such independent witnesses even after giving adequate opportunity to the plaintiff. The case record also shows that the plaintiff filed the examination of Chief of PW2 on affidavit, who was the scribe of exhibit one, at the later stage, that is after closing the evidences of the parties. As such, the same was rejected. It is also found in the case record that during the time of cross-examination of PW1, he admitted that the exhibit one was executed in the presence of one Stephen Anthony, Ishaq Ali, one Raju and Alauddin, and amongst them Stephen Anthony was expired. But the plaintiff did not take any efforts to produce the other witnesses, including the attesting witnesses, for evidence to satisfy the court in favor of his plea. Therefore, the sleeping act of the plaintiff shows doubt in execution of exhibit one by the defendant number one. Again, the learned appellate court remand the case record with direction that the exhibit one may be sent to the expert for opinion, and on the opinion of the expert, the case may be determined. The learned appellate court also directed to scrutinize the evidences of the parties if they wish to adduce any fresh evidence. However, in view of direction given by the learned appellate court, the disputed signature of the defendant, Desmond Anthony, was obtained in due process and also sent to the expert for opinion. Accordingly, the expert sent the opinion stating there inter alia that the documents in connection with the case had been carefully and thoroughly examined and compared with the supplied standard signature in all aspects of handwriting, identification and detection of forgery with necessary scientific aids available in the Directorate of Forensic Science, Assam, Kahilipara, Guwahati. The expert further opined that he examined and compared the question signature with the specimen signature in a number of sittings, but could not possible to express a definite opinion regarding the authorship of the question signatures on the basis of comparison with the materials in hand. However, the expert also kept a remarks that another attempt may taken to attain at the definite result if some signatures in English of Desmond Anthony, preferably taken around 1994, be sent to the expert for opinion. If we carefully scrutinize the opinion of the expert, then it is evident that he could not ascertain in his normal course of examination that the specimen signature of the concerned person is resembles with the question signature, though the expert kept reserved the second test, but he could not explain the reason as to why he could not ascertain the definite result and as to why the second test is required. Moreover, from the opinion of the expert in this instant case, it could be ascertained that there is no similarities of the specimen signature of defendant number one with the question signature. However, though the expert put remarks that a second attempt may be taken if the signature of Desmond Anthony is sent to the expert, but the plaintiff did not take any further step for the same. So here is the point, Lordship. After there is an opinion from the expert that it could not be opined whether the signatures are of the defendant, and a chance was given, but plaintiff remained, Lordship, silent. On the other hand, the plaintiff was also given chances for adducing the independent witnesses in favor of his case by the appellate court, but the plaintiff has taken no interest to adduce any independent witnesses. Apart from the arguments advanced by the parties, their pleadings, the oral evidences, the documents submitted, and the direction of the appellate court, the crux point of discussion was in respect of signature of the defendant number 1 in the exhibit 1 on the basis of expert's opinion. I have gone through the expert's opinion closely, and from the report, it is found that the expert could not ascertain the questions signatures with specimen signatures. On the other hand, though the expert kept reserve for second test, but the plaintiff has taken no steps further. If that be the position, then it is apparent that the question signatures in the exhibit 1 were not made by the defendant number 1. As regards independent witness as was to be adduced by the parties, it is also found that the plaintiff has taken no further steps to produce any evidence in favor of his case. Therefore, from the above discussion, it is evident the plaintiff's case is a false case. The defendant Desmond Anthony never executed the exhibit 1 in favor of the plaintiff at any point of time. As such, the issues are answered negative and against the plaintiffs. The plaintiffs are not entitled to get a decree as prayed for any reliefs thereof. And thereafter, all the issues are decided in negative against the plaintiff, Lordship. So accordingly, Lordship, order is at page 32. From the discussions and decisions on the point, it is found that the plaintiff side has not been able to prove the issues for determination. As such, I come to the reasonable finding that the plaintiff is not entitled to get a decree. Accordingly, the suit is dismissed on contest with cause. Thereafter, first appeal was preferred by the plaintiff. First appellate court judgment is at page 42. Annexure 4. And point was formulated by the first appellate court, page 45. Decisions and reasons thereof, Lordship, page 45. As the instant case pertained to execution of documents, so before pondering evidence on record as regards above point, it is pertinent to mention law relating to execution of documents. The word execution of documents does not mean only
Which part you are reading?
decision and reasons thereof, page 45, by the first appellate court. Point was formulated in paragraph 8, Lordship.
Yes.
So decisions given by the first appellate court is that as the instant case pertain to execution of document, so before pondering evidence on record as regards above point, it is pertinent to mention law relating to execution of documents. The word execution of documents does not mean only signing of a document. The person signing the document must be aware all the contents of document and consciously sign the document in token of acceptance of the contents of said document. If the execution of document is denied, it is for the party who alleges the due execution to prove acceptable evidence that executants affix his signatures to the documents after being aware of the contents of documents and in token of his acceptance so as to bind him. So here in this case, we have denied the execution of exhibit 1, Lordship. So it is the duty of the plaintiff to prove exhibit 1, Lordship. Further, it is also pertinent to mention that definition of proof given under section 3 of Evidence Act must be read along with section 67 of Evidence Act, which requires that there must be specific evidence that the signature purporting to be that all the executions is in the handwriting of the executants proved, therefore has to be given all the handwriting, signature and the execution of documents. Now in the instant case, as the defendant has denied the execution of Bainama dated so-and-so and receipt of any part of consideration amount, so it is incumbent upon plaintiff to prove that defendant had executed the Bainama and the signature of executants appearing in the Bainama belongs to defendant. As per Evidence Act, there are mainly two modes of proving handwriting, that is according to section 45 and 47 of Evidence Act. Now let us see whether the plaintiff was able to establish his claim as per aforesaid modes. Evidence from record disclosed that initially the plaintiff has opted for mode prescribed under section 45 of Evidence Act, that is expert opinion, but unfortunately the expert in his report stated that it is not possible for him to express the definite opinion regarding the authorship of the read enclosed signature stamped and marked as Q1, Q2 on the basis of comparison with the blue enclosed signature stamped and marked as S1 to S3 with the materials at hand. Further, the expert report also reveals that he had sought for additional admitted signatures in English written by defendant in his normal course of business during same party, that is around 1994, to form a definite opinion. So Lordship, expert was also asking for another attempt by the plaintiff, but plaintiff remains silent, Lordship. But evidence on record disclosed.
The documents were already sent to the expert.
So they asked for the no or Lordship opinion can
No,
be given.
what step the plaintiff was required to do?
He has to obtain again signature of defendant, or he has to ask the court to ask defendant to give the signature, admitted signatures of the year 1994 or in between the period, Lordship. And then again, those signatures to be sent to the FSL. It was the opinion of the forensic department that some admitted signature, more admitted signatures required, Lordship. But it was no step was taken by the plaintiff, Lordship. It is reflected in the trial court judgment also, and in the order sheet also it is reflected. And in this case, Lordship, plaintiff is very, Lordship, he is not trying to prove his case. His evidences were expunged. Thereafter, DW started.
His evidence expunged.
Yes, Lordship, his evidences were expunged earlier, Lordship. Thereafter, DW cross started. At that relevant point of time, Lordship, plaintiff again filed a petition for adducing the evidence of PW2. Then court accepted his PW2, and then he asked and filed another application for forensic report, Lordship. That was rejected. But plaintiff never challenged that order, Lordship. It is the only after dismissal of the suit, the first appellate court while remanded the matter, Lordship, then the first appellate court remanded the matter only on that point that Exhibit 1 may be sent for a forensic report. It is only the court who sent the Exhibit 1. At the instance of the court only, Lordship, not on the instance of the plaintiff, Lordship. He filed an application, his application was rejected, he remained silent. I have gone through the record, Lordship, all the orders are there. Even after the direction of the first appellate court, plaintiff remained silent, Lordship. No effort was taken by the plaintiff for resending the signatures and for FSL report. But evidence on record disclosed that no further signature of the defendant was sent to the expert during the course of trial. And in the meantime, defendant also expired. So in the meantime, 2012, defendant expired. His legal heirs were substituted. Now, as the expert could not express his definite opinion as regards authorship, so the plaintiff opted the second mode to prove his claim, that is section 47 of Evidence Act, which provides that when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of a person by whom it is supposed to be written or signed, that it was or was not written or signed by that person is a relevant fact. Explanation: a person is said to be acquainted with the handwriting of another person when he has seen that person write, or when he has received documents purporting to be written by the person in answer to documents written by himself or under his authority and addressed to the person, or when in the ordinary course of business, documents purporting to be written by the person have been habitually submitted to him. Now let us plunge into the evidence adduced by plaintiff to find out whether it supports its case and fulfill the mandate of law as stated above. Plaintiff PW1 in his evidence stated that defendant is the owner and possessor of the suit land described in schedule of plain by purchase, and he had made a proposal to plaintiff to sell the suit land for consideration amount of rupees. Again, the story, Lordship. Third paragraph, may I read? PW2 Mohammad Riazuddin, Tapadar alleged writer of aforesaid sale agreement, categorically stated in his evidence that he know both plaintiff and defendant of the instant suit, and he has, as per instruction of defendant, that is Desmond Anthony, wrote the aforesaid sale agreement, that is Exhibit 1. He categorically stated that the suit land measuring more than 1 Kadar 3 Justi was settled for sale between plaintiff and defendant at the consideration amount of rupees 1,50,000. He also stated that out of aforesaid consideration amount of rupees 1,40,000 was paid to defendant by plaintiff in his presence, and defendant Desmond Anthony put his signature on Exhibit 1 as an executor. He also exhibited signature of defendant Desmond Anthony as Exhibit 1-1 and Exhibit 1-2. He further stated that during course of transaction between plaintiff and defendant, one Ishaq Ali and Alauddin Lashkar were also present and put their signatures as witness, attesting witness in the aforesaid sale agreement. He also exhibited signature of Ishaq Ali and Exhibit 1-3 and signature of Alauddin Lashkar as Exhibit 1-4. The above version of PW2 corroborates and substantiates the oral account of plaintiff and also proved execution of Exhibit 1 document. Defendant could not shake their version along during cross-examination. It was chosen clear and consistent and corroborated. Defendant even failed to deny the version of PW2 during his cross-examination, nor put any suggestion to PW2 that he was not present during execution of Exhibit 1, nor put any suggestion that he has not seen executant put his signature, nor put suggestion that he is not a lead writer of Exhibit 1, nor put suggestion that he was not instructed by defendant to write Exhibit 1, nor put suggestion that no transaction of money took place in his presence between plaintiff and defendant. Defendant, by not denying and not putting any suggestion to the PW2, had indirectly admitted the version of PW2 and the case of plaintiff. So from above, we can safely hold that contents and execution of Exhibit 1 document is proved by plaintiff so as to make the contents of document admissible. Learned counsel for respondent, however, in course of argument raised a point that evidence of PW2 cannot be considered as it was submitted during course of trial after conclusion of evidence of plaintiff side. He also stated that learned Munsif also rejected the evidence of PW2 on the same count, and hence learned appellate court should also not consider his evidence. But in this regard, it is pertinent to mention that case record disclosed that learned Munsif by order dated 20/1/2014 permitted cross-examination of PW2, and the learned counsel of defendant side himself cross-examined PW2 on his evidence in chief. So according to permission by learned Munsif to cross-examine PW2 goes to show that he had modified his order and set aside, vacated his earlier order of rejecting the evidence of PW2. Further, when learned counsel of defendant himself had cross-examined PW2, so as per principle of estoppel, he is even barred from stating that evidence of PW2 is not acceptable. Hence, I am of the considered opinion that above argument of learned counsel holds no water. Besides above, the learned counsel of respondent also argued that Exhibit 1 is an unilateral agreement signed only by the vendor and not by purchaser, so it is not enforceable and no relief can be granted on the basis of unilateral agreement. In
So
this
it
regard-
was not signed by the purchaser.
Yes, Lordship. The purchaser not signed, their allegation is that, Lordship, only our predecessor signed the agreement. It is a deed of agreement we signed and we agreed to sell the land to the plaintiff, Lordship. So my case is that lordship plaintiff has to
Oh,
progress.
without the signature of the purchaser, how can you enforce it, exhibit one?
Lordship, that is the one aspect that was not looked into by the first appellate court, lordship. The deed of agreement was unilateral, unregistered, lordship. Even in on oral agreement also specific performance of contract can be granted, lordship. It is settled law, but lordship, when they are saying that the deed was executed by the vendor, the purchasers did not sign the agreement, lordship. So it is an unilateral, unregistered document. There is no question about that, lordship. As per section 101 Evidence Act, lordship,
Then why it was sent to the FSL, to the expert?
as we denied the signature of our predecessor in the exhibit 1, lordship. There is an application filed by the plaintiff that was rejected by the learned trial court on 8/11/2000. They filed an application for forensic expert opinion, lordship, that was rejected by the trial court. (11/8/2006).
Yeah, yeah.
In the order sheet of the trial court judgment, it is there. I have obtained the certified copy, lordship. May
But
I
you
take-
enclose it with the appeal.
No, lordship. Those are in the LCR, lordship. In the C file order sheet is there, lordship. And to the video. I see the video very well.
No.
Describe.
This one, I feel.
Order dated 11/8/2006, lordship. Duita petition is that? Duita petition is it?
Order dated?
11/8/2006. This order was passed before remand, lordship. They filed two petitions, Lordship. Both the petitions were rejected. I'm only reading this order because that Lordship to show the conduct of the plaintiff, Lordship. This is in the petition number 68-4 filed by the plaintiff stating inter alia that the witness of the plaintiff side being scribe of Bainama Patra in respect of the suit land was not present on the last date in the court, and a petition for adjournment has been filed which was rejected, and the evidence of plaintiff side has been closed, and the suit has been fixed for cross-examination of the defendant's witness. So at the time of defendant witness, they filed these two petitions, Lordship. The scribe being PW2 submitted his affidavit in chief and is present in the court, and thus the plaintiff prayed for accepting the evidence of PW2, otherwise the plaintiff shall suffer irreparable loss and injury. Under the circumstances, it is prayed to accept the evidence of PW2 for hearing of the suit on the part of the plaintiffs. I have also seen the petition number 70/7 filed by the plaintiff stating inter alia that the plaintiffs filed the suit for getting the suit land registered in their names on the basis of the Bayanapatra dated 1/2/1995, being Exhibit 1, executed by defendants in favor of the plaintiffs, which the defendants denied by filing their written statements in the suit. Thus, it is necessary to ascertain the facts that whether the said Exhibit 1 has been executed by the defendant Desmond Anthony or not by handwriting expert. Otherwise, the plaintiff shall suffer irreparable loss and injury. Under the circumstances, it is prayed for passing an order for sending the Exhibit 1 to the handwriting expert for opinion whether the said document has been executed by defendant Desmond Anthony or not. Heard the learned counsel for both sides at length and also have perused the case record, and it appears that the suit is an old pending one since the year 1997, and the evidence of plaintiff side has been started long back, and plaintiff side got ample opportunities for reducing their evidence. And lastly, on 24/1/2006, the learned ad hoc additional district judge Karimganj, before whom the suit was pending, closed the evidence of plaintiff side by an elaborate speaking order, and the plaintiff side did not approach for review of the said order. And thus the said order remain in force is one aspect of the matter, and on the other hand, the petition filed by the plaintiffs for accepting the evidence of PW2 does not reveal any ground why on the last date the PW2 was absent in the court, and there is no whisper regarding the order dated 24/1/2006. So far, sending Exhibit 1 to the handwriting expert is concerned, the petition filed by the plaintiff itself speaks that the document has been denied by the defendants in their written statement, which was submitted on 3/10/2002, but the instant petition is filed on 7/2/2006. That is almost 4 years later than the date of submission of written statement in the suit. Further, the petition does not disclose any ground and or any reasons as to why the petition for sending the document to the handwriting expert could not be filed earlier. Now, in view of the discussions made above in respect of both the petitions filed by the plaintiffs, it appears that those petitions are filed at the very belated stage of the suit, and the mandate of amended Code of Civil Procedure is to curtail delay and to dispose of the matter in expeditious manner, and on that count alone, both the petitions filed by the plaintiff are devoid of merit, and thus the same are considered and stands rejected. So, Lordship, on this date, two petitions were rejected. They never challenged this order before the Honorable High Court, Lordship. PW was closed, and their prayer for sending the Exhibit 1 for forensic was closed. Suit was dismissed, Lordship. It is only by the first appellate court held that the Exhibit 1 to be sent to the forensic, and then it was remanded back to the trial court again for retrial for fresh decision, Lordship. And then Exhibit 1 was sent to the expert opinion, And thereafter, expert opined that it cannot be possible to give opinion on the basis of the signatures. Some more signatures required. Thereafter, also plaintiff remained silent, Lordship. And then, Lordship, the PW2 was cross-examined after remand. But in this case, DW1 cannot be cross-examined as Lordship, it was closed by the trial court, Lordship. So, Lordship, my humble submission as per 101 Evidence Act. Burden of proof upon the party who come to the court to assert a fact, Lordship. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. So here in this case, Lordship, the plaintiff is silent. His conduct is very poor, Lordship, in handling his own case. In this case, I am relying some judgments, Lordship. We have to 1996 2 SCC page 704, Lordship. When there is an expert opinion is there, Lordship, the court cannot take its own records to examine the records, Lordship. Para 11, similar are the cases regarding 65 witnesses at least. This is not seriously disputed by the learned counsel for the first respondent. Though the signatures are challenged, the learned judge overruling the objection raised by the learned counsel for the appellant hearing that unless the disputed signatures are compared with the admitted signatures, the same cannot be taken into account, proceeded to compare the signatures by himself and found that they are either similar or slightly varying. It appears that the learned judge has decided the question of void and invalid votes on insufficient materials and evidence in the case. Majority of the witnesses denied that they have voted more than once, and they have also denied their signatures in the counterfoils. Under such circumstances, the learned judge could have summoned documents containing admitted signatures for comparison by an expert, and also by comparing them himself. Instead, the learned judge undertook the hazardous task of comparing hundreds of disputed signatures which are not having individual characteristics to set aside the election of a candidate, the appellant hearing. This judgment was relied on in our High Court decision, Lordship. And one another 1997 7 SCC.
Not necessary if a Supreme Court has already settled the matter, then.
Lordship. And this decision was relied on by our High Court, Lordship, that is 2015 to GLT, Lordship.
That's why I'm saying
Lordship.
that law is settled by the Supreme Court.
Yes.
What is the point for looking into the judgments of High Court?
GLT is more similar to the facts and circumstances of my case, Lordship. So these are the citations I'm relying, Lordship, on the basis that when there is an expert opinion, there is a direction for the matter was remanded only on that ground that the exhibit 1 is to be sent to the forensic and scientific expert opinion may be taken. Lordship, without doing that, on the basis of Lordship PW2, the suit was decreed. So my humble submission, when the plaintiff has failed to prove his case, Lordship, the judgment given by the first appellate court is not correct, Lordship. Lordship may kindly set aside the judgment passed by the first appellate court, Lordship. But this is my humble submission.
No, it is a fact that it was second time not sent to the expert. But whether the witnesses examined by him are insufficient to establish the same?
Lordship,
It is a fact that exhibit 1 was not sent to the FSL for second time.
Lordship. But
But
PW2 is a
whether
crime.
the evidence of other witnesses are insufficient to establish the same?
Only on the basis of PW2, Lordship. PW2 is the scribe. So his statement also, there are some contradictions. And court has shifted the burden to the defendant. Defendant has not put these questions. Defendant has not put suggestions to PW2. Only on those grounds, Lordship, PW2 was accepted by the First Appellate Court. I have already read the portion of the First Appellate Court decision, Lordship. Page 48, Lordship, defendant even failed to deny the version of PW2. So burden was shifted to defendant, Lordship. It is the case of the plaintiff for specific performance of contract. It is the duty of the plaintiff to prove his case. That is why, Lordship, section 101 was, while admitting the appeal, the substantial question of law was formulated on section 101, Lordship. If Lordship plaintiff proves his case, then defendant's Lordship evidences may be considered. And it is settled principle, your Lordship is also aware, if the plaintiff is a plaintiff suit cannot be decreed on the weakness of the defendant's case, Lordship. But page 48 is completely on that basis. Defendant failed to put any suggestion, defendant failed to cross-examine PW2. Only on those grounds, Lordship, PW2 was accepted and it was held that PW2 proves the exhibit 1. He's a scribe only, Lordship.
Yes.
Yes, completed, I think. Well, the plaintiff's suit is, I'm for the plaintiff respondent. Trial court dismissed the suit. First appellate court, initially there was a remand. I'll have to refer to the operative part of the order passed by the first appellate court when the matter was remanded to the trial court once again. I'll refer to that. I'll refer to you. Then first appellate court after remand, the evidence were taken, whatever evidence were thereafter the first appellate court ultimately decreed the suit of the plaintiff. Here, one important aspect is there, apart from what has been argued by my understand. And as your lordships are aware, my lord, these issues are framed on the basis of a assertion made by the plaintiff and denied by the defendant. Plaintiff's case is that there was an agreement to sell, and he has paid for a decree for specific performance of contract. And lordship may kindly have a look at the prayer from the plaintiff. Nine. Oh, nine. Page 9 of the memo of April, lordship may kindly have a look. Page 9. Small a, that the plaintiffs be allowed to deposit the remaining consideration of rupees 10,000 towards the price of the suit land in the court, and defendants be directed to receive the said sum and execute the final registered sale deed in respect of the suit land in favor of the plaintiff and deliver to them the khas position thereof within the time as stipulated by the honorable court. Now, plaintiff has said that there was an agreement for sale on 1st of February 1995. This is the suit of the plaintiff, my lord. Now, the defendant files a written statement, my lord. The lordship may kindly turn to page 23. In the real fact, small e and f are the two paragraphs where they have disputed the execution of Bainama dated 1st of February 1995.
Page number 23.
23, my lord.
Paragraph number?
Paragraph E and F, my lord.
Mm.
That the plaintiff number 1 being the group persons of plaintiff number 2 and 3 with evil and ulterior motive and for illegal and wrongful gain and in collusion with each other with a view to harass and cause loss and suffering to the answering defendant, alleging false and concocted averments created a alleged fraud, unilateral, unregistered Bainama dated 1st of February 1995 and filed the instant suit against the answering defendant. F. That the plaintiff never executed the alleged Bainama dated 1st of February 1995 in favor of the plaintiff or received any amount from the plaintiff for sale, the scheduled property of the suit. The scheduled land of this suit within the area of Badarpur town and for transfer of the town area land, there was no provision necessity for obtaining permission from authority concerned on the alleged prior period of 1/2/1995 to 31/1/1996. That the next paragraph, that the stamp of the alleged Bainama deed which is submitted by the plaintiff in the court was purchased by one Sri Riazuddin Tapadar on so and date execution of the same was 1/2/95. That in the alleged agreement, it is further shown that an amount of 1,40,000 has already been paid on 1/2/95 and the remaining amount of 10,000 has to be paid within 31st January 1996 and the said agreement is an unregistered unilateral agreement. That from the contents of the alleged agreement dated so, it is crystal clear that the alleged agreement is nothing but a collusive and fraudulent one and the plaintiffs are not entitled to any relief in the suit. Rather, the suit of the plaintiff is fit one to be dismissed in limine with cost. Now, this is their stand. They are basically saying that they have never executed. Specifically, their signature is there in the agreement or not, they are not specifically saying, but they have taken a general plea that they have not executed the agreement. This is their stand. Now, based on these allegations, the trial court framed the issues, which your lordship will find at page 29.
Yes.
On page 29, there are as many as 6 issues. Specifically, there is nothing but issue number 5 and 6 are possibly the issues under which this discussion came up for consideration, whether the plaintiff has been able to prove that due execution of the agreement to sell. Issues are whether the plaintiff is entitled to get a decree as prayed for, to what relief or relief the plaintiffs are entitled. So, on this page itself, at the bottom, you will see issue number 5 and 6 are discussed, and then page 31 it has been held. Therefore, from the above discussion, it is evident the plaintiff's case is a false case. The defendant Desmond Anthony never executed the exhibit 1 in favor of the plaintiff at any point of time, as such the issues are answered negative and against the plaintiffs. And I am raising a plea here, where the defendant, having, as per the written statement, denied the execution of the agreement to sell. All these discussions have taken place, but then I find from the record that defendant number 1, who the sole defendant has examined himself as DW1. He submitted his examination in chief, and therefore he never presented himself or turned up before the court for cross-examination. So in that view of the matter, his my lord, evidence was expunged. If his evidence is expunged, I can give you lordship the date of the orders passed, my lord.
No, later on it was allowed.
Oh, gosh. No, after remand, chance was given.
Even
to
then, he did not
take
appear.
evidence, lordship. In the year 2012, defendant died, lordship.
Acha.
My lord, if he died on his behalf, some other person could have come and deposed in support of the written statement, but the pleadings in my submissions, my lord, pleadings in the of the written statement were never proved by the defendants. We have just now checked up from the order sheet. For the defendant. On 19th of Lordship may take a note, my lord, 19th of February 2007. 14th of February 2007. After repeated adjournments were taken, they again filed an application for adjournment seeking an further opportunity for allowing the defendant DW1 to be cross-examined. That prayer was rejected on that day, my lord, his evidence was expunged. That is an order of the trial court passed on 14 February 2007. record flag mark flag mark. My learned colleague will flag mark all these orders, so lordship will find it convenient. Thereafter, on 12th of March 2007, a petition was filed under 151 seeking a further opportunity to present DW1 for his cross-examination. That was also rejected. We are, my lord, marking all these pages, my lord, for your lordship's convenience. So, my lord, thereafter, my lord, the judgment was delivered and on appeal was taken. Then on appeal, there was a remand. My lord, in the remand, there was a direction which I'll just read, my lord, for your lordships. The remand order is relevant to find out, my lord, for what it was remanded. This also, well, we have flag mark here also. And I'm reading just two paragraphs from the remand order, my lord. Para 17 first. Para 17 of the remand order, my lord. This remand order is dated, my lord, 8/6/2010. 8/6/2010, passed in title appeal number 30 of 2007. By the learned civil judge Karimganj, man. And I am reading two paragraphs from the remand order. Para 17, man. The trial court had analyzed the evidence properly and had dismissed the suit by giving cogent reasons. The first appellate court reversed it by wrongly placing on the defendants its observation that then the execution of an unregistered document put forth by the plaintiff was denied by the defendants it was for the defendants to establish that the document was forged or concocted is not sound proposition. The first appellate court proceeded on the basis that it is for the party who asserts something to prove that thing, as the defendant alleged that the agreement was forged. It was for them to prove, but the first appellate court lost sight of the fact that the party who propounds the documents will have to prove it. In this case, the plaintiff came to court alleging that the first defendant had executed an agreement of sale in favor. The first defendant having denied it, the burden was on the plaintiff to prove that the first defendant had executed the agreement and not on the first defendant to prove it negative. The issues also placed the burden on the plaintiff to prove the document to be true. No doubt the plaintiff attempted to discharge his burden by examining himself as also scribe and one of the attesting witnesses, but the various circumstances enumerated by the trial and the High Court referred to earlier when taken together rightly created doubt about the genuineness of the agreement and dislodge the effect of the evidence of PW 1, 2, 3. We are therefore of the view that decision of the High Court reversing the decision of the first appellate court doesn't call for interference. As in the present case, the respondent defendant since inception of the suit before trial court is denying the execution of Exhibit 1, which is not properly proved by evidence of scribe Muhammad Riazuddin Tapadar, is in my opinion need to be examined by handwriting expert by taking samples of signatures of the respondent defendant Desmond Anthony to ascertain real controversy in respect of admissibility of Exhibit 1. Placing reliance on both of rulings of the apex court, I am of this considered view that the trial court, by not sending the Exhibit 1, an unregistered agreement, execution of which is denied by the executed respondent defendant, need to be sent to the expert for its examination, as was observed by the apex court in the ruling cited above. Accordingly, the decision taken by the trial court is set aside and quashed. Then, my lord, the last paragraph I'm reading, my lord. In the result, finding merit in the appeal, it is allowed on contest and the judgment and decree passed by the trial court in title suit number 143 of 2006, dated 5/4/2007, is set aside and quashed and the suit is remanded back to learned trial court with a direction to send the Exhibit 1 agreement for sale to expert with the burden to bear the cost by the plaintiff appellant and to decide the suit, this is important, and to decide the suit afresh on the basis of opinion of expert on Exhibit 1. And in case the parties will feel that their witnesses will be examined, there should be proper opportunity to the parties for it. So one party is to send the Exhibit 1 to the FSL for opinion, expert opinion, and second party, in case the parties will feel that their witnesses will be examined, there should be proper opportunity to the parties. So opportunity was given to it is fresh evidence also. This is the remand order. Now, after that, the document was sent to the FSL. As my learned friend has read, my lord, the FSL report possibly says that unless the document, contemporary document is given of 1995, 1994, because the agreement is of 95, it becomes difficult to give any specific opinion as to the genuineness of the signature. I'm just reading the opinion. The documents in connection with title suit number so-and-so, received by letter number so-and-so, dated so-and-so, have been carefully and thoroughly examined and compared with the supplied standard signatures in all aspects of handwriting, identification and detection of forgery with the necessary scientific aids available in the Director of Forensic Science, Assam, Kailipara, Guwahati. The red enclosed questioned signatures stamped and marked Q1 and Q2 were examined and compared with the blue enclosed signatures stamped and marked S1 and S3 in a number of sittings. But it has not been possible to express a definite opinion regarding the authorship of the red enclosed signatures stamped and marked Q1, Q2 on the basis of comparison with the materials at hand. However, another attempt will be made to form a definite opinion in this case. Some admittedly genuine signatures in English written by Desmond Anthony in his normal course of business during same period with preparation of deed, namely around 1994, may be sent along with these documents for comparison. This is the opinion of the expert panel. Well, my submission first of all is that when my submission, there is no denial at all of the execution. They have taken a plea of denial in the written statement, but the written statement, the pleadings in the written statement having not been proved by adducing any oral evidence, my lord, no credence can be given to the plea taken in the written statement about the execution of Exhibit 1 document, my lord. The question of, my lord, further proof, etc., will come only when there is a denial. Here is the case, there is no denial absolutely. The entire written statement has to be ignored for the simple reason that there is no evidence from the side of the defendant to prove the contents of written statement, my lord. For that, possibly I need not show any judgment, my lord. The order 14 itself says, my lord, I'm reading order 14, rule 1, sub rule 3, my lord.
Order 14, rule,
Order 14, rule 1,
rule 1.
sub rule 2 and 3.
Yes.
My lord, order 14, rule 1, if your lordship takes up kindly, my lord. One says framing of issues. Issues arise when a material proposition of fact or law is affirmed by one party and denied by the other. Then 2 says material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. 3 is more important. Each material proposition affirmed by one party and denied by the other shall form the subject matter of a distinct issue. Now, here is a case where there is an assertion by the plaintiff that there has been an agreement of sale and you have taken this much of money and you have not executed the sale deed. That is why he has come before the Honorable Court, before the trial court for a decree of specific performance of contract of agreement to sell. Now, civil procedure court says that only when you deny it, there will be a question of deciding an issue. Here is a case where they have filed a written statement, denied it, but this averments made in the written statement has not been proved by adducing oral evidence. It is very routine thing, but unfortunately, the defendant never presented himself, defendant DW1, only witness for the defendant, never presented himself for cross-examination. Therefore, the last order of the trial court was of 25th of January 2007. Before that, if your lordship goes to the order sheet, my lord, there are orders passed on 30th of August 2006, 11th of September 2006, 25th of September 2006, then 17/11/2006, 15/12/2006. On all these occasions, my lord, adjournment petitions were given, seeking time for cross-examination. Then 3/1/2007 also, 17/1/2007, 25/1/2007. Then on 14th February 2007, by passing a long order, my lord, the last part of the order by which the evidence was closed, my lord, I am reading, my lord, only last part. as also peruse the case record. Upon perusal thereof, it is explicit that defendant side already availed sufficient adjournments after commencement of hearing, including statutory limited period of adjournments. Order dated 25th of January 2007 passed by the learned predecessor further reflects that the defendant side was allowed the last adjournment with a caution that no further adjournment shall be granted. Instant suit is a long pending one since the year 1996, which requires expeditious disposal as per the mandate of Civil Procedure Code. Though defendant side annexed one affidavit to the instant petition appears to be shown by advocate's clerk, but in absence of any medical certificate or other cogent evidence, this court is not convinced as to the claim of illness of DW1. Hence, prayer stands rejected. Evidence of DW1 is forfeited. Evidence of DW1 is forfeited for not appearing for cross-examination today. Fixed 26th February 2007 for argument, both sides shall ensure hearing. Then, my lord, thereafter they filed a petition on 26th of February 2007. Praying for under section 151, praying for a further opportunity, my lord. Then December, the learned trial court passed an order on 12th March 2007, my lord. I'm just indicating we have flag mark also, my lord. Learned counsel for the plaintiff and defendant filed their respective hajiras seen petition number so-and-so under section 151 of the CPC filed by defendant side, wherein it is inter alia prayed that DW1 be allowed to face cross-examination as on 14/2/2007. Due to illness, he could not appear in the court enclosing a medical certificate. Heard submissions of learned counsel for the defendant and objection raised by the plaintiff. Considering facts and circumstances, it appears that the petition is the result of afterthought, hence prayer stands rejected. Fixing 23rd March 2007 for argument. Thereafter, argument took place and the judgment was delivered on 5th of April 2007. Then an appeal was taken, and by the appellate judgment, the matter was remanded back to the trial court. After it was remanded back to the trial court, the order applied.
So according to you, there is no substantial question of law here.
My lord, yes. Then after remand, there was another opportunity to, apart from my lord, a direction that exhibit 1 should be sent to the FSL for expert opinion. There was also an opportunity to both the sides to adduce their evidence, as your lordship is, I read there. Thereafter, my lord, even after that, they did not. My lord, there are two orders relevant, my lord. One is 5/9/2014, which is learned counsel for the both sides filed hajira, fixed 22nd 10/2014 for DWs. One more opportunity was given, my lord. After remand. 5/9/2014.
Next.
My lord.
Next date.
Next date fixing 22/10/2014. On that day, my lord, this order was passed. Learned counsel for the both sides filed hajira, but no witness is present on behalf of the defendant nor prayed for adjournment. Hence, evidence of defendant side is closed. Fixed 21/11/2014 for argument. On 12th of December 2014, my lord, arguments were heard, and on 2/1/2015, the judgment was delivered, my lord. So, my lord, my submission is in the absence of any written statement. Written statement has to be totally ignored because there is no oral evidence to support the plea taken in the written statement, any of the pleas, my lord. As a result, my lord, there is no written statement and there is no defense and there is no objection to the decree to be passed. Even then, my lord, there are cases where the Honorable High Court, the Supreme Court has said that the plaintiff has got a minimum responsibility of prima facie proving his case. Now I'll come to the, my lord, judgment passed by the first appellate court. My lord, first appellate court has seen, my lord, that the, in terms of section 45, the expert of the Evidence Act, my lord, expert opinion was there, but his opinion is neither here nor there. No firm opinion was given. So based on that, no decision could be taken. Then, my lord, the learned court below has taken recourse to section 57, 47, I'm sorry, my lord. 47 of the Evidence Act says, my lord,
Yes.
Yes. Section 47 reads like this, my lord. Opinion as to handwriting when relevant. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person is a relevant fact. Explanation is given, my lord. A person is said to be acquainted with the handwriting of another person when he has seen that person write, or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business documents purporting to be written by that person have been habitually submitted to him. That means, my lord, if an expert opinion in terms of section 45 is there, it is there. Of course, my lord, even the expert opinion given under section 47 or 45 of the Evidence Act is not conclusive. Court can go further, court can disbelieve it. It is not conclusive. But here is a case we are concerned with the burden of the plaintiff to prove his case. 45 somehow, because of the absence, my lord, there is a mention in one of the in the judgment, of course, that the defendant side also said we are unable to give any admitted signature of 1994. They also say it. Now, 47 gives power to the court to form an opinion about the handwriting, etc., of a document on the basis of, my lord, the opinion of a person who has seen him writing, etc., my lord. Now, PW2, my lord, PW2 was examined, my lord, in order to PW2 was examined in order to, my lord, bring the case within the four corners of section 47 of the Evidence Act. Into the post. My lord, the evidence in chief of this PW2 is very limited, just one paragraph. I may read it back. I, Sri Riazuddin Tapadar, aged about 60 years, son of late so-and-so of district so-and-so, residing in Badarpur, Karimganj, by profession deed writer. He is a deed writer, madam. By profession deed writer, do hereby solemnly affirm and declare that the statements I am giving below are true and nothing but true, and no part of it is false, and I conceal nothing regarding the subject matter of the suit. I know the plaintiff, Lordship may kindly note, I know the plaintiffs and defendants of this suit, that I am the deed writer of the suit land, which is an agreement for sale of the suit land. Exhibit 1 is the said deed. I have written the deed under instruction of defendant Desmond Anthony, which is very important. The suit land is measuring 1 Kedar 3 Justi 4 Cons 6 Gonda 1 Kora, which is settled for sale between the parties at rupees 1,50,000 as consideration. Out of the said rupees 1,40,000 is paid to the defendant by plaintiff on the date of so and so in my presence. And the defendant Desmond Anthony put his signature on exhibit 1, which is exhibit 1-1 and exhibit 1-2. Ishaq Ali and Alauddin Laskar were also present while Desmond Anthony executed the agreement and who put their signatures as witnesses in this deed. I know the signatures of Ishaq Ali and Alauddin Laskar. Exhibit 1-3 is the signature of Ishaq Ali and exhibit 1-4 is the signature of Alauddin Laskar. They put their signatures in my presence. This is his evidence on affidavit, my lord. And then there was a cross-examination, which I'll read. আমি এক্সিবিট একটা মহাদয় বাদী আব্দুল হাদির বাড়িতে লেখা হয়েছিল। উনার বাড়ি বদরপুর টাউন হইতে 3 কিলোমিটার দূরে। বিবাদী মৃত ডেসমন্ড অ্যান্টনির বাড়ি বদরপুর টাউনে মিশন রোডের নিকট খাদিমান এলাকায়। এক্সিবিট 1A খাদিমান বলিয়া লেখা নাই, স্টাম্পটা কার নামে মনে নাই। এক্সিবিট 1 এর স্টাম্প কে ক্রয় করে মনে নাই। এক্সিবিট স্টাম্পকে সেদিন আনিয়া দে সেদিন আনিয়া দে মনে নাই। স্টাম্প সেটা মনে নাই। স্টাম্প আমি নিয়াছি কিনা তাহাও মনে নাই। সাক্ষী ঈশাক আলীর বর্তমান মৃত বাড়ি মহাশলে এবং আলাউদ্দিন লস্করের বাড়ি বদরপুর টাউনে। গৃহীতা ও 3 জন আব্দুল হাদি, আজিমউদ্দিন, আব্দুল হুসেন। কি দেখিয়া এক্সিবিট 1 লেখি তাহা মনে নাই। বায়নার মূল্য 1,50,000 টাকা দেওয়া হয় 1,40,000। জায়গা 1 কেদার so measurement is given, my lord. আলাউদ্দিন জীবিত না মৃত জানি না। কয়টা স্টাম্পে লেখি তাহা মনে নাই। দিনের বেলা 2:30টায় লেখা হয়, 2:30 লেখা হয়। সবাই উপস্থিত ছিলেন। সম্পাদন তারিখ 1/2/1995। সত্য নয় যে সেদিন ডেসমন্ড অ্যান্টনি আব্দুল হাদির বাড়িতে যান নাই। আব্দুল হাদিতে টাকা দেন নাই সবাই সামনে। আব্দুল হাদি টাকা দেন সবাই সামনে। সত্য নয় যে ডেসমন্ড অ্যান্টনি টাকা নেই নাই এবং কেউ টাকা দেই নাই। এক্সিবিট 1A 1-2 সেগুলা মিথ্যা। এক্সিবিট 1 এর সম্পাদনের আগের দিন ডেসমন্ড হাদি আমাকে ডেসমন্ড এবং হাদি আমাকে এক্সিবিট 1 সম্পাদনের বিষয়ে অবগত করেন। His statements are very, very clear. বেচা বিক্রির ফয়সলা সম্পর্কে আগে কি হয় আমি জানি না, তবে আগের দিন আমাকে লেনদেন সম্পর্কে জানান। He was informed about the লেনদেন ম্যাটার। সত্য নয় যে মিথ্যা বলেছে। মানে one statement, one question is not there that this is not his signature. This is not the signature of the vendor. This question was not put to him in the cross-examination. So they are scared that if this question is put, he will say yes. There is not even a suggestion. They are only saying exhibit 1A, exhibit 1-2, সেগুলি মিথ্যা। There is a difference in saying that the signature is false, and there is another thing that he did not put his signature. When he says in the examination chief that he put his signature, the 2 attesting witnesses put their signature in my presence. Lenden was discussed in the previous evening, and the payment was made in my presence. 1,40,000 was paid. Every statement is there. My submission before Lordship, my lord, by examining PW2, the plaintiff has discharged the minimum burden he has in the absence of any written statement to prove his case for the purpose of getting a judgment. Then, my lord, the question of this burden under section 101 will be very, very minimum. Under section 101 of the Evidence Act says, where whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts, must prove that those facts exist. So I have proved with the help of PW2 at least the facts necessary to prove my case, that the vendor put his signature, vendor took advance, there were 2 attesting witnesses, they have now died, and the previous day there was a discussion, and I am the deed writer, I have written the deed. There is no suggestion that you have not written the deed. So the fact of writing of deed by PW2 is also admitted. The signature is not disputed in the cross-examination. So the burden of proof which the plaintiff had in the facts and circumstances of this case, in the absence of written statement, has been very carefully and adequately discharged by the plaintiff in terms of section 101 of the Evidence Act. That being the position, my lord, the learned First Appeals Court's judgment declaring the suit in my favor need not be interfered with, my lord.
Yes, any reply?
Yes, Lordship. In this case, Lordship, they are again and again saying the conduct of the defendants. But Lordship, I am on the part that what is the conduct of the plaintiff, Lordship? How he is able to prove his case or not, Lordship? There is a clear direction by the First Appellate Court while remanding the matter, Lordship, to decide the suit on the basis of expert opinion on Exhibit 1. That is the first point, first direction given by the First Appellate Court, Lordship. And it was cited by the learned trial court also in page 29. Paragraph 6, Lordship. The remand direction was cited by the trial court, paragraph 6, page 29. On perusal of the case record, it is found that the learned appellate court directed this court to decide the suit afresh, mainly taking the view of expert opinion on the Exhibit 1. So this is the direction. But the First Appellate Court has not gone into that point, Lordship. The remand direction was not maintained by the First Appellate Court, Lordship. In addition to that, Lordship, the parties, if the parties, Lordship, it is written in case the parties will feel. So this is second part. In case the parties will feel that their witnesses will be examined, there should be proper opportunity to the parties for it. But the remand order was clearly stating that to decide the suit afresh on the basis of opinion of expert on Exhibit 1. So there was no endeavor by the plaintiff for sending the Exhibit 1 again for expert opinion, Lordship. And this decision clearly states that 2015 2 GLT, Lordship. It clearly says, paragraph 13, Lordship. Paragraph 13, in the instant case. In the instant case, the trial court had for justifiable reasons referred the sale deed Exhibit 1 for opinion of handwriting and fingerprint expert, and thereafter on the basis of such opinion had gone on to hold that the sale deed under question was not executed by Ranubala Borthakur. Once the scientific expert's opinion was available on record, the learned First Appellate Court could have either agreed with such opinion or in the event of any further doubts remaining in the matter could have referred the matter for a fresh opinion. But in the present case, what can be seen from the record is that the learned judge has discarded 4 as well as CW1 and thereafter arrived at a conclusion by visually comparing the signatures himself, drawing an opinion which was contrary to the expert opinion. It appears that such a recourse has been taken by the learned First Appellate Court by relying upon Section 73 of the Indian Evidence Act 1872. And thereafter section 72 was cited, Lordship. Paragraph 14, it says, from a bare reading of section 73 of the Indian Evidence Act 1872, it leaves no room for doubt that the court would have the power to visually compare the disputed signatures with the admitted signatures. However, the core question that would arise for a decision in the present appeal is whether the powers available under section 73 of the Indian Evidence Act can be exercised by the court so as to form an opinion as regards this disputed signature handwriting by making a visual comparison, drawing a conclusion which is contrary to the expert opinion obtained under section 45 of the Act 1872. In other words, would it be permissible for the court itself to become a handwriting expert and substitutes its views with the expert opinion obtained under section 45 of the Indian Evidence Act merely based on a visual comparison of the signatures? In the case of Ajit Sawan Majagvai versus State of Karnataka, that was also I have given, Lordship, reported in 1997, 7 SCC 110 in paras 37 and 38, the Honorable Apex Court, while interpreting the scope and ambit of section 73 of the Indian Evidence Act, has held that although the court has power to compare the disputed signature with the admitted one, yet normally the said exercise should be left to the wisdom of the expert. Paragraphs 37 and 38 of the said judgment are quoted below. Then paragraph 16, Lordship.
Not necessary.
Lordship. So in this case, once there is a direction by the first appellate court, once there is an endeavor taken by the plaintiff for expert opinion, Lordship, that too on the advice of the first appellate court only, not on the endeavor by the plaintiff itself, Lordship. The first appellate court has committed perversity by relying on the evidence of PW2. And Lordship, the DW evidence in regard to that, Lordship, Ordership. DW2 was submitted on 2006, Lordship. I have gone through the order sheet. DW2. Evidence in chief was submitted in the year 2006 or 2024-1-2006, Lordship. Defendant has submitted his examination in chief by the entire order I am reading, Lordship. On 24-1-2006, both parties are present through their learned advocates in petition number 38-3 filed by the plaintiff side, seeking adjournment of hearing on the
The
ground
question
of
is that whether his evidence is his
Whether he
evidence
was
is impeaching
cross-examined or not.
cross-examination or not.
Lordship, why he was not cross-examined, Lordship? It is not the case that defendant did not adduce evidence. Defendant filed
No,
written statement.
I am referring to PW2. Have you been able to impeach his veracity?
Lordship, he could not say who purchased the stamp paper. He could not say who has procured the documents in the entire cross-examination, Lordship. I will come to that, Lordship. Before that, DW2 was submitted in the year 2006, Lordship. And it, as my learned senior friend has pointed out, that they did not try to prove their case. It is not that case, Lordship. The written statement was submitted and immediately in the year 2006, they have adduced the evidence of DW1, Lordship. On that date, 24-1-2006, both parties are present through their learned advocates in petition number so-and-so filed by the plaintiff side, seeking adjournment of hearing on the ground of ailment of the plaintiff, Abdul Hadi, heard submissions of learned counsels of the both sides. Also peruse the case record. It appears that the plaintiff side has got sufficient opportunity to adduce evidence. Prayer is rejected after consideration. So, Lordship, plaintiff's prayer was rejected. Defendant has submitted his examination in chief by affidavit, copy of which is received by the plaintiff side. Cross-examination of the defendant could not be taken for want of time. So it is not the fault of the defendant, Lordship. He adduced the evidence. He repeatedly appeared before the court. Only on one date when he could not appear, Lordship, on medical ground, court held that due to medical ground, he has sought for adjournment. No medical document was adduced, so DW2 was not closed, Lordship. He was not allowed to be cross-examined. But after remand, Lordship, when again the PW2 was allowed to be cross-examined, DW2 in the year 2012, he died. So he was not cross-examined.
Then
2000.
is there any value of his evidence in SIF, examination in SIF?
Lordship, maybe, but it is not the case of the defendant. It is the case of the plaintiff. He has to prove his own case, Lordship. There was no endeavor from the plaintiff's side, Lordship. He has filed his evidences long after closing the plaintiff's evidence at the stage of DW, Lordship. Again, praying for adducing the evidence of PW2, Lordship.
Maybe.
Lord.
So
So
at least
there
he
was-
adduce evidence.
Lordship. And there is a direction by the first appellate court that the exhibit 1 to be sent for forensic report, Lordship. That was incomplete. That
Okay,
direction
okay,
was-
okay, okay.
And the PW2 Lordship, he has already stated that the stamp paper who purchased, I am not aware. He is simply deed writer, Lordship.
Okay, can we discard his evidence on that ground alone?
No, Lordship, PW2, so far I have gone through PW2, Lordship.
Pardon, Miss R. Sodre, learned counsel for the appellant, and Mr. D. Mazumdar, learned senior counsel, assisted by Mr.
R. Sharma,
Learned counsel for the
Rupam Sharma.
respondent. Argument concluded, judgment is up.
Lordship.
Well, one judgment.
You have referred on judgment, yes.
Well, one.
What is that judgment?
Well, one judgment I want to actually have the word about doctrine of non-traverse. Here is a case whereby written statement was filed, but in the absence of any evidence, it amounts to non-denial of the claim ever met. So it will be governed by doctrine of non-traverse. Well, one judgment today I have not got. Tomorrow morning I'll submit to
No, okay, no problem.
And Lordship, on that, plea, I can also give one judgment, Lordship, that on the
Yes,
weakness,
yes.
on the weakness of defendant's evidence, Lordship, the plaintiff suit cannot be declared. And there are several judgments. It says that, Lordship, when defendant is absent, in case, Lordship, the suit is decided expertly. Even then, Lordship, it is the duty of the court to decide the suit, Lordship, on the basis of the evidence and pleadings, Lordship.
Tomorrow morning I'll have. Deep flow.
Obliged.
Item number 18. Item 18.
None appears for the petitioner on call or lays the matter after vacation.
Item 19.
My lord, my senior is coming.
Pardon? Who is your senior?
Josimuddin. Josimuddin.
Next one. So time is very short, or we'll fix it next date.
My only thing, my lord, our execution case has been stayed on a petition, it is not maintainable. My execution decree was passed in my
What to
favor.
do? I am ready, but the other side is absent.
Well, he's coming, I think, my
Hmm?
senior is coming.
Then time also may not permit today to finish the hearing. Sort that.
My lord, next. Again. On 19th, 19th one.
19, this month may not be possible.
Thursday.
First week of October.
First October. we can-
First of all. Please do.
Item 20,
As agreed by learned advocates of both sides, recess and list the matter on 1st of October.
My lord, in respect of item 20, my lord, learned engaged counsel MH Loskor has gone because of certain urgency. He has got a telephone over
Hmm.
there, my lord. So he
So adjournment
yes, he has
on
gone.
the
My
pair being made by Mr. Your good name,
name is SR Borgoi on behalf of MH Loskor, my
S.R. Borbuya, learned counsel, appearing on behalf of Mr.
MH Loskor.
M.H. Loskor, learned counsel for the appellant.
Yes, my
List the matter.
any day.
List the matter.
item 21,
This will lordship. Lordship, senior, learned senior counsel Mr. A.C. Sharma is on the way to discourse. He's in a ground floor.
So when to be listed?
Lordship, he's on his way to discourse. Lordship.
Pardon?
He is on his way to discourse. Lordship. Just 2 minutes, Lordship.
2 minutes. So first week of October. Next item.
item 22. Item 22,
May I please, your lordship? Lordship, I have already taken consent from the other side. It is the first time that you have appeared for the respondents. Any advocate had appeared before this respondent for his honorable court, my lords. And we have been led by I'm led by an advocate from Delhi, my lords, which is outstation advocate. So we won't be able to do the hearing today, my lords. However, my lords, we like to take the leave of this court that the matter can be fixed on a later date, so that we can do a substantial hearing on the matter, my lords.
Okay.
My lord, fix the date.
No, date, actually what has happened since, my lords, there are holidays in October, and my lords, the council is from outstation, my lords, something after 18 November, my lords.
My lord,
Any
it
date,
will be too late.
any date after 18 November, my lords.
My lord, we will observe.
Any date after?
Any date after 18 November, my lords.
It will be too late. There is some urgency, lordship.
My lords,
It has been observed in the order also. Last to last occasion order. It has been
with,
observed.
with utmost humility, I may say, my lords, in order dated 6 October 2023, it is the other side.
No, it
was
is
not taking steps.
2019 matter. Why should
The
we?
problem is this, my lord, the respondents, 2 respondents have they died. So therefore, the LRs had to be replaced. My lord, if my lord goes through the order dated 6 October 2023, it is the petitioner themselves who has been delayed taking steps.
No,
my lord.
no,
They have
not
filed their written
November.
objections.
My lord,
Immediately after reopening.
My lord, 25th of October maybe. 25th of
my
October.
lord, that I'm so sorry, my lord, since I'm led by an outstation counsel. I
Or
would not
maybe
have-
is that ground for adjournment?
No, there is not a ground for adjournment.
Then?
I'm so deeply obliged, my lords. But the only problem is that, my
We
lord,
are accommodating you.
yes, my lords. My lord, something in November, my lords. We'll do a
No,
substantial,
sorry.
we would not take any adjournment, my lords.
Sorry,
on 29th October.
My lord, the leave of the court may be given to my lords.
sorry.
My lord, just so sorry,
Don't
my lords.
insist it.
No, not regarding date, my lords. Not regarding date. My last submission, few respondents will file their reply. 2 respondents are left to file the reply. We seek the leave of the court.
Pardon?
Basically, there were 3 respondents earlier, my lord. Then they have been replaced by the LRs. So now there are total 8 respondents. Most of them have submitted their reply. Only 2 respondents are yet to file the reply. In the due time, we'll file the reply, my lords.
Okay.
So that leave of the court may be that leave may be given.
My lord, may fix it on 25th.
29th, 25th, there are already so many cases hearing. already.
28th.
No, 29th is Tuesday, that is why. 29th is Tuesday, hearing matter. That is
So,
why 29th.
respondent number? Leave of the court is required for respondent number?
1.1 and 1.4, my lords.
1.1 and
1.4.
Okay. Take down.
My lord, it has been wrongly listed for hearing, my lord. Otherwise, the CRP is not admitted. It ought to have come up for admission hearing. Only last occasion also it was a
Into metro for hearing.
Order service completed here.
Yes,
Even
there
better,
there is specific order there, Lordship.
Well, the matter has only been delayed because my lord, LRs will be replaced. Otherwise, there is no delay. We have filed people have my lord, the respondents have filed a reply in person also, my lords.
Services completed.
My lord can also see have it. I could also bring your my lord
Admission hearing.
My lord, may please,
29th.
28, then it can be.
Pardon?
fixed on- Can it be fixed on 28, my lord?
28.
Because
Okay, okay.
admission
28.
hearing.
Item 23.
Much obliged.
So, Mr. Khan, the matter is ready for hearing.
My lord,
Yes, Lordship.
my lord,
Ready?
hearing matter, lord. My lord, we are ready, lordship.
But today may not be possible to conclude the argument.
Yes, lordship, that is.
So, in the first week of October,
First week of up to 4 lordship. Can it be on lordship, it's September on 26th of September, lordship.
26 not possible.
26
Already fixed several matters.
or 24 lordship. Because we have some urgency lordship against concurrence finding and despite of lordship, because of lordship interim order, we are not approving the.
Okay, in the first week of October, we'll try.
1st October, Lordship.
1st October.
1st October.
1st October.
Item 27.
Okay.
Lordship, we are aggrieved by the judgment and order dated 21/7/2023 in the miscellaneous first appeal number 70 of 2023. In this case, my lord, the impugned judgment will Lordship find at page 17.
Who is for the respondent?
The respondent counsel B. Chakravarti is there, Lordship. As per last order dated 9/8/2024, Lordship, the counsel was there, Lordship.
So, heard miss, your good name?
I'm Sharma.
Learned counsel for the appellant, none appears for the respondent on call. List the matter after vacation.
Lordship, can it be on 26th of September, Lordship?
Before vacation, not possible.
Any date,
Same
Lordship?
thing may happen.
Lordship, can it be on the 1st of October? Oh, sorry, the vacation will be started.
29th October.
29th October. Obliged.
Hello, sir. Item number 21, senior counsel for the petitioner is present, appellant is present.
May I please, your lordship? Well, this is a partition suit. Partition suit, there is a property purchased by the.
We have already fixed the date, next date.
No, but what I want to submit is this. Is a partition suit. Property was purchased by the father. Sons and daughters were filed to one of the sons. The suit was declared. Well, it is a family matter. And some of the plaintiffs who are the respondent here, they are residing outside. They have no
interested in the property.
Hmm.
So I may pray that it is a property in Guwahati. I may pray that the matter may be sent to the mediation so that the
Mediation.
case can be compromised because all will get the property,
Hmm.
but the appellant, he is looking after the property.
No, that's all right. If there is possibility of negotiated
it is a
settlement, we can
family
refer to
property.
matter.
Because if it is suit is decreed, even then the execution it will take time. If it is sent to the mediation, then the matter can be solved.
Yes.
Yes, my lordship, there is no instruction from our client to this respect. But suggestion made by the petitioner, land council is good, but fact is that already decreed the suit.
No, that is all right. Even though it is decreed, it can be referred to mediation.
Yes, sir, the
This
trial
court can
court-
refer to mediation.
Yes, sir, the
Yeah.
trial court
In
already
that case, matter can be solved.
divided equally amongst the appellant as well as respondent, equally. So here in this case, they filed a appeal on the ground that daughters are no entitled to the property of the.
I am not on this matter.
No, he is not on merit of the case now.
Okay,
He
well,
is for negotiated settlement. Let it go to the mediation center.
yes, ma'am.
Hmm?
We need some instruction from this side.
Instruction. What instruction is required? If they are ready to.
Yes, madam.
Hmm?
Fix for mediation. Actually, there somebody is staying in Shillong. Respondent one in Delhi, Bangalore, and somebody is staying in Nagaon. So we need to inform them.
My lord, the whole thing
So
is this.
mediation is a process to come all the party together.
Oh, yes.
So you need some time to.
Okay, we'll
complete
give
the
you time.
mediation.
Suggested that then. When we can ask the parties to appear before the mediation center? When?
That is because I am the appellant will appear as the respondent. According to their convenience, they may fix the date. We are in Guwahati. we have no
Suggested
problem.
that.
Icon Sahiba.
On 1st of November.
Okay. 1st of November.
When?
1st of November.
1st of November. Okay. Heard Mr. A.C. Sharma,
Yes,
Senior Counsel,
yes.
assisted by Mr.
First of November, holiday.
Learned Counsel for the appellant, and Mr.
NP Borua.
MP,
NP Borua.
Learned Counsel for the respondents.
Holiday.
Mr. Sharma, Learned Senior Counsel submits that the matter relates to partition of
Ancestral property.
ancestral property and
Self-report.
and
Not insist.
there is chance for reconciliation between the parties, then as such, the matter may be referred to mediation center, High Court Mediation Center, Guwahati High Court Mediation Center. The Learned Counsel for the respondent also agreed to the proposal so offered by Mr. S.C. Sharma, Learned Counsel for the appellant. In view of above, this court is inclined to refer the matter to the High Court Mediation Center. The recessal is the matter before the mediation center, before the mediator, mediation center Guwahati on 1st of November.
First of November is a holiday.
On
4th.
1st it is holiday.
4th of November. Okay. 4th of
First.
Highly appreciate.
Yeah.